At your pleasure, Mr. Hall.
Okay. Does they make these things in larger size?
I printed one out for you. Should be in your stack of paper.
It is. The only problem is I can't find my stack of papers here.
Oh, okay.
Okay. All right. I want to apologize before we get started for running late. So it's just one of those situations. I know that we do have some experienced reviews here, and I'll have to just
That would be great.
call on. I've got this right here. Tell me who that is. But before we get started, I need to call the meeting to order. I need a motion to adopt the agenda. Okay. All right, roll call first. Starting with my left, Mr. Green.
I'm Michael Green from Johnson City, Tennessee.
Rosemary Johnson, Paris, Tennessee.
Mark Johnstone, Jackson, Tennessee.
Nancy Point, Rogersville, Tennessee.
Norman Hall, Brentwood, Tennessee.
Urban Phillips, Nashville, Tennessee. Jason Covington, Nashville, Tennessee.
Tim Walton, Collierville, Tennessee.
Thank you, everyone here. Mark, welcome to the commission. We have a new member today, Mark Johnstone. And Jackson, we're glad to have Mark with us. Mark has been on the commission once before. Also agreed to serve as the chairman. So we're glad to have Mark back on the commission. Forward to him sharing with us his many experiences as a former chairman.
Thank you.
So next, adopt agenda. Do you have a motion to adopt the
Motion
agenda?
to adopt.
Motion to adopt. Second. All in favor say aye.
Aye.
Opposed, like sign. Motion carries. Okay. We have an opportunity to review the October commission meeting. If so, do I hear a motion to accept?
I so moved.
I'll second.
Motion by Nancy Point, second by Herb Phillips. All those in favor say aye.
Aye.
Opposed, like sign. Carries. Okay, down to experience reviews. We have Ms. Nancy Point. Would you like to report, please, ma'am?
I would like to make a motion that we approve the experience credits for Mr. McMakin.
I hear a second.
I'll second.
We have a motion, second. Discussion. All in favor say aye.
Aye.
Opposed, like sign. Motion carries. Mr. Green.
Yes, sir. I would make a motion to approve the Mr. Patrick Chaffin's application to upgrade to certified residential.
Okay. Motion been made. Do I hear a second?
Second.
All in favor say aye.
Aye.
Opposed, like sign. Okay. The next one is mine, and I've met with Mr. Paul Becker this morning. We did not have time to complete. This is a rather involved situation. In addition to the experience, there was some discussion between him and his former employer, and we're trying to work through these situations. I have told him that I am going to defer making a report on him at this meeting, and that I will personally meet with him when we get through after we adjourn, and at the next meeting that I will bring this up, and he's acceptable to that. And so consequently, I will not be making a report. Therefore, my Vice Chairman, Mr. Michael Green, will not get to preside.
Hi, Jim.
Okay, Mr. Herb Phillips.
Yeah, I'd like to make a motion to accept Michael Brandon Hall's report to the next condition.
Okay, the motion, do I hear a second?
I second.
Got a second. Ms. Phillips. All approved, say aye.
Aye.
Opposed, like sign. Okay, motion carries. Education report, Dr. Varela is not with us today. He's in the midst of exams. I hope he passes. But anyway, I think we have a list by Dr. Varela of the various courses and his his recommendations about these classes. The report that I'm reading indicates that he would approve these 4 courses or classes.
Mr. Hall?
Yes.
The first page of the report, there are 1, 2, 3, 4, 5, 6, 7, 8,
Oh, I'm sorry. I
10
had the
courses.
second page. I had
That's
the
okay.
second page. I
There's-
overlooked the first page.
There's 10 courses on the report that I emailed to you. The last one was still pending, but Dr. Brilla did email me on Friday with a recommendation to approve the last course on the list.
So all of the courses are now, how about the first 1, 2, 3, 4 on that first page from Dynasty School? Are they approved or not?
4 pending
Yes.
an approval letter from Hondros. We need the secondary approval letter.
Okay.
Hondros is the primary. We need a letter from Hondros saying they approve this secondary provider.
So we are going to delay voting on those 4, correct?
The vote I would like, they won't get physically approved until the letter is received.
Okay, well, let's just do this then. Let's go ahead and just take the first 4 that we are waiting for approval. And that way we can go ahead and pass it on those 4, subject to receiving approval
Okay.
from Honduras and from Dr. Rolla. Do I hear a motion to that effect?
Make a motion.
Got a motion? Second?
I have a question.
Yes, sir. Mr. Reed?
Who or what is Hondros?
Yeah, Hondros is a primary course developer provider, and they've probably, almost probably, authorized Dynasty as a secondary course provider, allowed them to use their course materials. The way sometimes schools like Appraiser Institute allow a secondary course provider to use their course materials. I don't know if Appraiser Institute does that anymore, but they used to.
So that's
but-
just the name of a company?
Yeah,
Okay.
and this packet didn't include that letter that says that Dynasty is approved to use Hondros' course materials, which is
I wasn't
a
familiar.
requirement.
I didn't know who that was.
Good question. Thank you, Mr. Reed. Any other questions, concerns? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Now we have need a motion on the remaining courses that have been approved by Dr. Rolla. And I can move that we accept those. Do I hear a second?
Second.
Discussion?
Motion was Mr. Hall,
Yes.
second was Covington. Thank you.
Hearing no discussion, all in favor say aye.
Aye.
Okay, approved. Next item is application review character question.
Let's call the second page of the course approvals. The instructor approvals for Stephen Maher and the individual course approval for Star Jenkins. Was that part of that vote?
Yes.
Oh, it was, okay.
Mr. Chairman,
Yes.
is Sean Thompson here this morning? Yes, Mr. Thompson.
Mr. Thompson, oh, the
Okay.
owner of the appraisal management company? No, he's from out of state. We don't generally require it of them. Sorry. Integrity Appraisal Management Company LLC, application number 157, submitted an application to become a registered appraisal management company. Sean Thompson was identified as the controlling person, and he checked yes to character information 3, which reads, have you ever been convicted of, pled guilty, or pled no contest to any criminal offense, or is there any criminal felony or misdemeanor charge now pending against you? The supplemental letter indicated he was arrested in May of 2004 and March of 2009 for DUI offenses. He indicated that the fines, fees, and probation criteria have been met. This matter is brought to the commission for consideration because the offense is less than 5 years ago. I recommend approval of the application. This one is outside of the director consideration because it's less than 5 years old per commission policy number 9. So it needs to be presented to the commission.
So the recommendation is that we approve his application.
Yes, and if you look on the iPads, on pages, 19, 20, 21, 22, 23, and 24 are his application and his letter of explanation regarding what happened.
Mr. Chairman, I'd like to ask Director a question. Are you satisfied that everything's been satisfied as far as the probation, all the fines been paid? I mean, is that something you got off? You have some of these look like
All I have is the application information he submitted with his application.
And all of
We
this was...
don't have authority to run background checks on
Okay,
him.
so all of this was submitted with his application, correct?
He submitted this information to us.
Texas Department of Public Safety.
Do I hear a recommendation as to whether we accept it or not?
It all looks legitimate to me. I don't see any reason not to. I'm going to make a motion that we accept it and approve this application.
Second?
Second.
A second motion. Any further questions?
I want to understand, you recommend approval, Ms. Avers. Is it, the DUI is a felony, correct? I mean, and that's why it's before.
Misdemeanors was generally correct.
The character questions request criminal, felony or misdemeanor, anything. So, and he reported it on the reports it says misdemeanor.
So would it vary based upon what the item was? So in this case, it's a DUI, so we're okay with that? Or
That's what I
do we have a
recommend.
criteria
If it,
for offenses?
if it were substantially related to the appraisal industry, I would not recommend for approval. If it was something for theft or money laundering or something related substantially, or if their appraiser credential had been revoked for some reason in another state, or something substantially related to the appraisal or the financial industry, or substantial harm to the public trust, something like that. It's clear that the person has made some bad decisions, but I don't know that is particularly grounds to not approve a appraisal management company license. But it's the discretion of the commission to determine that, not me.
His base of operation is where? Texas? Where will his business be located?
Texas.
Texas. Just based on the trend line, he's due for another one next year. So I'm wondering if there's any liability to it. And I don't mean to make light of this. Is there liability to this commission or to the state if we approve this and something happens? Not that he'd be practicing in Tennessee, but I'm just trying to think through this. And I realize that's probably outside your purview.
I have no idea.
Well, I don't think he's like an appraiser without me interfacing directly. We've had some things a lot more serious than this in the past.
And you approved them?
And that would seem to be what the criminal courts would be for. If he got convicted again, he'd go to jail, and his license wouldn't be of any use to him anyway.
Okay, any additional discussion? We got a motion, second, all in favor say aye. Opposed, like sign, motion carries. legal report.
Okay, this one's kind of lengthy, so if you guys have
If you
questions.
would just wait 1 second, I left a lot of this stuff in the other room.
Okay.
They go through the back.
Okay.
The report that you sent to us previously is the same as you got.
That might lock, you might freak Mr. Hall out.
We can hear it all the time.
I'm not sure if I flipped the switch this morning on that lock mechanism.
That might not be a bad thing.
But yes, after he gets back, we may shut the door again.
Look, I could blame Nicole for laying all this stuff on me, but I'm not gonna do that.
Yeah, you can see the size of the trainee files he got this morning. He had one trainee to interview, and most of that material is one trainee file.
All right, I apologize.
Okay.
Okay, let's go.
Okay. The first item on the legal report is 2011-02-8201. Complaint was filed by a consumer and commercial property owner and alleged the respondent misreported occupancy, square footage, rental rates, and income capitalization rates. Additionally, the complaint alleged the sales comparison was performed incorrectly. The complainant alleged that respondent admitted there may have been some errors, but that nothing was done about it. The respondent sent a lengthy response indicating that he thought this complaint was rooted in the complainant's unfortunate economic circumstances with the subject building. Respondent stated that his client, a large regional bank, accepted the appraisal report as it was prepared and no revisions were requested. Respondent also suggested that the complainant's fundamental misunderstanding of the appraisal process led him to faulty conclusions regarding the credibility of the appraisal report. At the time of the commercial property inspection, one of 4 office spaces in the subject building was unoccupied and unfinished. Subsequently, it was revealed that the complainant wanted the appraisal to include a prospective value premise, assuming his occupancy of the vacant office suite, but this was not requested by the client. Respondent states that the square footage utilized in the appraisal is credible, and the capitalization rates are supported by 2 widely accepted industry publications. Additionally, respondent stated that the comparable sales utilized in the report are credible, and in his professional judgment, they are the best substitute properties available for comparison. Respondent stated that the appraisal that is the subject of this complaint is credible, and it has been reviewed and accepted without any revisions requested. The reviewer conclusions are that the sales comparison was not appropriately supported. The report does not provide adequate reasoning, nor has sufficient support been provided for the analysis performed, adjustments made, and conclusions offered in the sales comparison approach. The reasoning recommendation is that the reviewer found that the inconsistencies and lack of analysis reduce the credibility of the opinions offered and the reliability of the conclusions presented in the sales comparison approach to value. These items can have an effect on the intended user's ability to understand the reasoning presented. The appraisal at issue was performed in 2011 at a time when the respondent had been licensed certified general for about 19 years. Based on the research completed for this review, it appears the respondent has identified sales that are similar to the subject from potentially similar market areas. This information appears to have been properly collected and verified. There was a lack of analysis of those markets as they relate to the subject area. As such, council recommends closure with a letter of warning regarding the issues noted by the reviewer.
We've just heard the information. Do I hear a motion?
I move to accept the recommendation.
Move to accept. Do I hear a second? Discussion? All in favor say aye. Oh, I'm sorry, Mark.
Mr. Chairman, the letter of warning, how does that impact their record?
Letter of warning is a non-disciplinary action. It is recorded. It can be considered if a complaint in the future had similar findings, like a new complaint has been filed, you were warned about this particular type of violation in 2012, and you've done it again, it can be considered a mitigating circumstance to, or an aggravating circumstance to future discipline. So, in the future, it could be considered as something to decide to discipline someone more heavily, but it's not a disciplinary action. It does not go in the disciplinary action report. It's not a publicized discipline. However, if anyone asks about the complaint or asks for a copy of the letter of warning, all of that record is public record information.
May I ask one other question, Mr. Chairman? And this, I'm not sure if this is for legal or Ms. Avery. In looking at that, one thing, I'm just asking from the process standpoint, when the respondent, when they, with this being the complainant being a large institutional bank, they're going to be a sophisticated user of appraisals, and do they, in terms of reviewing, if it's a summary report for restricted use, or depending upon what that is, that the respondent provided, does the reviewer get all that background to be able to make a real good clue? I mean, because it just looks to me like when I look through that, I could argue either side of it, really, if you wanted to.
The reviewer gets everything.
Because okay, thank you.
She made a comment that the complainant, the specific complainant in this case, wasn't the bank itself. I don't know if that makes a difference.
It was not the bank. Oh, I thought it said it was. Oh, okay.
What's the difference between a closure with a letter of warning and dismissal with a letter of warning?
Well, it's kind of like she said, if it's just if they get a closure with a letter of warning, they're going to get a letter laying out, sort of like, could have been a possibility that you violated these, but it's not a disciplinary action, but it's more than a dismissal, because if it were a dismissal and it was included on a future legal report, we wouldn't look at it as something that had just been dismissed. We would look at it as, well, they previously got a letter of warning for these particular things. So it's not just like it gets closed. It's closed with.
Dismissal is considered you did nothing wrong. Close can be for a variety of reasons. Close can be we have insufficient evidence. We've closed things because the respondent passed away, and really, why would you prosecute? There's a variety of reasons you can just close something because you just are not going to take action. But it doesn't necessarily mean that there wasn't something there. It just means you're not going to do anything in this situation, or you just don't have grounds to proceed. Letters of warning, caution, and instruction means that there may have been something there, and please take this under advisement. Don't do it again. And discipline is discipline. And only the discipline is published to the disciplinary action report, and all discipline goes to the Federal Registry.
So this will or will not go to the
This
registry?
does not go to the Federal Registry. This is not discipline.
Johnson?
I'm fine. Thank you.
Any other questions, concerns? All those in favor say aye. Aye. Opposed, like sign. Motion carries. Next.
Item number 2 is 2012018321. It's complaint was filed by a consumer and alleged an incomplete appraisal by a respondent. The complainant also alleged that respondent did not return the phone calls to the complainant and paid for the appraisal and did not get community service. The respondent states that when the appraisal was ordered, there was mention of a mobile home on a 1-acre lot located behind the subject property, which was thought to be owned by someone else. Respondent first submitted the appraisal without the 1 acre, and then at the request of complainant's attorney, respondent added in the 1 acre and resubmitted the appraisal, which was paid for by the attorney. Respondent states that complainant filed the complaint before checking with the attorney to see if the appraisal had been corrected. Reasoning and recommendation would be respondent resubmitted a second appraisal at the request of complainant's attorney. Counsel spoke with the attorney on November 14, 2012 via telephone, and he indicated that this complaint was centered around an estate property dispute between family members. Complainant's attorney indicated that respondent had provided him with the corrected version of the appraisal report that included the 1-acre lot that was in question as the subject of this complaint. Complainant's attorney stated that respondent performed his job and followed up with everything that complainant's attorney requested, and that respondent's actions with the original appraisal report were not in any way intentional. Thus, counsel recommends closure of this case with no action against respondent.
Do I hear a motion?
Motion.
Got a motion, second. Mr. Phillips, Ms. Johnson. Discussion? Hearing none, all in favor say aye. Opposed, like sign. Next one.
Number 3 is 2012-017651. This complaint was filed by a consumer and alleged unlicensed conduct on the part of respondent. Respondent, who holds certified general appraiser licenses in New Jersey and Texas, admits in his response that he did not have a non-resident temporary practice permit at the time the appraisal was conducted in the state of Tennessee, as required by TCA 6239-338. Reasoning and recommendation would be that respondent submitted an appraisal report for a non-residential property. Respondent is not licensed as a real estate appraiser in the state of Tennessee at this time, nor was he licensed as a real estate appraiser in Tennessee at the time of the appraisal. Respondent also submitted that he did not have a non-resident temporary practice permit with the state of Tennessee at the time the appraisal work was done. Our file contains the appraisal report submitted by respondent, including a letter from respondent to complainant, stating that respondent was submitting its valuation report containing information considered relevant to both the value of the property.
I'm sorry, I thought I cut that thing off.
Okay.
I apologize.
And the method by which respondent analyzed collected data to arrive at the value conclusion. The report contained an estimate of the market value of such property at the time and appears to be intended to be used as an official appraisal report by complainant. The report submitted by respondent is very lengthy and detailed. As such, counsel recommends the authorization of a civil penalty in the amount of $1,000 for unlicensed activity on the part of respondent to be settled by consent order or formal hearing. Civil penalty should serve as a sufficient economic deterrent while also protecting the interest of the public.
Okay, having heard the complaint, any comments, questions? Go ahead.
Got
Tim?
concern looking at the complaint that's filed here. It looks like, it's obviously a commercial report, possibly an airport. I'm going to assume the appraisal fee on something like that could be thousands of dollars, if not possibly tens of thousands. To me, $1,000 penalty for practicing as an appraiser in our state without a license opens the door. This guy may have, let's say the fee was $10,000 on this thing. He comes in and gets slapped with $1,000 penalty. He still made $9,000 practicing as an appraiser in our state without a license. So that just the size of the penalty, I think everything else is fine with, but the size of the penalty I'm a little bit concerned about.
I agree with you, Commissioner Wald. I was going to ask how much a temporary practice permit is not expensive. How much is it?
$150. He got one several months subsequent to the appraisal.
Was it for this work?
Yep.
Well,
Different
leave on
grounds
the
to
record.
deny him.
Now got it.
Yeah.
He ASC requires we process temporary practice permits within 5 days. I didn't have grounds to deny him, and you can't possibly process a complaint in 5 days.
Do you know when the report was written?
I don't recall off the top of my head.
I mean, I can look at it and see if you want exactly.
I guess the reason I'm asking is, based on, updated use path and disclosure, can we find out what his fee was for this?
You certainly could in a formal hearing. But the violations for, that you can punish him is between $50 and $1,000 per violation. Well, and there is each day of continued violations, so,
What's the maximum?
50 to 1,000
Per day?
per day per violation. There isn't a number of violations maximum, but the only violation noted thus far is unlicensed conduct, just one. So that would, the maximum on that would be 1,000. However, we could have the appraisal report reviewed for use path compliance, and that could be per violation also.
Yeah, I guess you could find out the date of the appraisal.
Well, I don't know. I feel that the guy's done the appraisal. He did come back and file for a license after the fact. We are going to be finding him $1,000. I think he understands that if he moves forward on this thing, he will suffer consequences if he ever does it again. If we find out about it, that's the key. If we find out about it.
It will be reported to the National Registry that accepts this discipline or go to court if formal hearing is proceeded. And then his home state would be notified, of course, too, who also may take discipline against him for having violated their provisions.
And yes, I must say that it's not a continuing violation from one of the appraisals, so we can continue approving it. It's just one incident.
So the maximum fine was $1,000. Is that correct?
$1,000 per violation per
That's
day.
one violation.
So, we only know about one so far, so yes.
It was just unlicensed activity on that one specific instance that we know.
So you're saying per day doesn't apply?
Correct. Because it's not an ongoing violation.
Wouldn't it have been ongoing between the time he set foot in the state and the time he got his temporary license?
Typically, the way continuing violation works is you have to have proof of every day of violation. So if we had documentation that showed how many days he actually worked unlicensed in the state, we could maybe then assert a continuing violation, but at this point, we don't have that. Frankly, that's what it is.
So you couldn't consider, like, knowing our business, you couldn't consider the fact that the appraisal was signed and dated May 15th, and then he applied for a temporary permit and got into compliance on, say, June 15th.
So the problem with that would be between May 15th and June 15th, we don't have any evidence that he did anything else. He'd actually have to be violating practicing in Tennessee.
How about the time span between the date of inspection and the date he signed his report?
Well, if you could prove that he worked on it every single day in between, yeah,
I see.
that's why it's, the continuing violation is a little difficult to prove in this types of cases.
Thank you.
I agree with Commissioner Green, it's a pretty serious violation. In fact, in the state of Alabama, if you call over there disinspecting the property, they can come and arrest you.
Yes.
Pick you up.
But at this point in time, I understand the law correctly, kind of tied to this $1,000. Is that correct or not?
Without any further evidence of the actual, time that he worked on this. And it seems like we just have evidence of one violation.
Mr. Johnston?
Would it be possible to maybe look at picking up an extra day or two based on his travel time or her travel time to the state? because as soon as she touched down and drove into the state, that starts ticking a violation, because they wouldn't be driving here if they weren't doing an appraisal. And then the date of inspection would be in the, it would be in the report, the date of inspection, and, you know, maybe some confirmation, there could be some nuggets in there that would allow you to discern or find out that they were here in 3 days, and that becomes $3,000.
The investigation may cost us more than the school penalty would be, I mean, to determine
But
that.
the attorney could look and probably spot it in 30 minutes.
Do we have a copy of the appraisal?
We have a copy of it in file, yes.
Do we have a court file?
Can we, let me make a suggestion here. Can we defer a ruling on this at this point in time to give legal an opportunity to review the report and at a minimum find out the state sent out a date of inspection and the date of report? If that 2 days are different, as Commissioner Green indicated, that would indicate 3 separate violations. When we say it's 3 days between the date of the inspection and the date of the report. If there's 3 days and that's 3 violations, then it would be a $3,000 maximum fee. Is that correct?
Yeah, I mean, it's in your discretion to do that if you want. I
Well,
can't promise that there's going to be something in the file that will be helping you make that determination, but I mean, if you want to look
okay,
at
what
that.
I'd like to do is just defer until we have an opportunity to review it, and then we can make a decision at that point in time if we'd like to do it. Is that acceptable with the fellow commissioners?
Well, I would also like to suggest that it's very clear to the complainant, because the complainant could probably talk to us about their ground time with the respondent. The complainant could probably talk about meetings they had, and they have met with them every day, looking at their report. So, more information. They are right here?
They're on there.
Okay. So they're PREAC rules and
So they didn't necessarily regulate daily practice or whatever, they'll handle complaints that will come in. But Dodd-Frank, the legislation, is what sets forth the boundaries of how the AMC works. If you are an AMC and what that makes up. And if you're not, that makes up. So we report, or we are held by Dodd-Frank legislation. And it's very neat. Very neat.
well, I'm asking because it seems like these kinds of complaints, I suspect, are going to get more frequent. With my residential brethren and sisters agree. So it seems like I'd like to see a copy of what AMCs can and can't do and what standard we're judging. Yeah.
Click on your, instead of the rule one, click on your laws. You switch on your iBooks to laws. Click on, if you touch it, just touch the center of your iPad, and then in the top left-hand corner, touch library. And then you'll see one that's orange and it says laws. Touch that, and then turn to page 27, which is 6239-419. That's the part that lays out the statute on improper influence of an appraiser. It says basically anybody who works for an AMC, it lists on a whole bunch of may not, through coercion, extortion, collusion, inducement, withhold payment or threaten to withhold payment, withhold business or future business, condition the fee on a subsequent event, I'm paraphrasing. Number 5, request an appraiser provided appraiser is paid an estimated correct buyer value. Require them to collect the fee, require them to sign an indemnity clause. That's it. And then there's some prohibited requirements in Order 20. So if someone filed a complaint against an appraisal management company, it would have to be, they would have to be able to establish that the AMC did some one of those things. And, yeah, it's difficult. One of the areas that I found, a potential sand trap for appraisers is that there's a requirement that, the AMC not kick them off the panel for violating USPAP without notifying them and giving them an opportunity. Well, in order for an appraiser to complain about that, they essentially have to turn themselves in. File a complaint, say they kicked me off for violating USPAP, and I didn't violate USPAP. Okay, give me a copy of the appraisal, we'll have it reviewed for compliance with USPAP. If you did violate USPAP, they have grounds to remove you from the panel. If you didn't violate USPAP, that's the only time that they can kick you off, and you can say that they treated you unjustly, at which point they would have to put you back on their panel. But, essentially, if you filed a complaint against an AMC for that, you would be turning yourself in.
Well,
Subjecting yourself to the review process, and
not necessarily
any violation of USPAP would be, essentially Dubuque had to turn it, file a complaint against the appraisers who were, they violated use path. They turned themselves in. It's happened.
I have a question, and I think it is part of this. Generally, when an appraiser goes to you, as a appraiser, we've got to be informed to use that. And I think that's kind of the meat of this complaint, is that agency is reviewing this appraisal and not necessarily complying with standard 3 use that. So essentially what I'm hearing here is that standard 3 really is its use path, so it's not applicable to the agency, correct?
It's not applicable to a non-appraiser. An underwriter doesn't have to comply with standard 3. Now, if they render an opinion of value, it would have to be appraised. So if the opinion of value is part of it, then the law automatically applies to them. They have to comply with use value. But if they're just doing compliance reviews, desk reviews, whatever you want to call it, technical reviews, it doesn't apply to them. That's just, back me up on this. Because part of appraisal practice for as long as I've been an appraiser, and it goes back further than me, had the writer call in the questions saying, page 20, and these questions, whatever, it's just normal business practice to have to answer an underwriter's questions or thoughts. They have to be crazy, sometimes they're out of the area, have like regular report. So, in appraisal, is that why there's 6 appraisers required to be on the appraiser commission. It's all going out there.
This is a great letter article to appraisal about feel like the AMC is this, that, and the other. This is that, for consideration, just to the ledge that's not sufficient. We're kind of gray on all this, I'm certain.
So Jason, would you like to write an article on this? Maybe,
Excellent, thank you. Thank you.
Let's defer this topic.
Just food for discussion.
I think there was a call for a vote.
I think I can relate to where the appraiser coming from, it's really more a position of frustration than real violation. Appraisers are kind of powerless in a lot of circumstances, and I think it's fine.
Okay, I believe we have a motion to accept the recommendations on this one.
Motion and a second.
Do we already have a motion?
Mr. Phillips made the motion, Ms. Point made the second.
Okay. That discussion, all in favor say aye. Opposed, like sign. Okay.
Item number 5, 012009161. Complaint is filed anonymously by Appraiser and alleged respondent. Complaint and Appraiser alleged that an appraisal was accepted by an appraiser not completed by Appraiser to the respondent without granting the appraisal. The complainant also alleged violations of the contract indicating prior to accepting the assignment or insurance agreement performing the assignment. The appraiser must properly identify the problem. The appraiser takes a specific job and is not completed due to lack of competency for that particular job assignment. The respondent will downgrade the appraiser. The respondent states the complainant appraiser only viewed the order on the auto advertisement but never accepted it. The respondent states that had the complainant appraiser actually accepted the order, the complete address of the subject property would have been immediately visible to the complainant, which would also have included an engagement letter from respondent with explicit directions to the appraiser regarding the requirement of the appraiser's competency. The respondent states this method is an effort to cut down on order stealing by other appraisers. The respondent also indicates that under its proprietary appraisal order fulfillment process, an appraiser is advertised orders based on the appraiser's detailed profile maintained by respondent. Thus, respondent is offering the appraiser's work based on information about the type of property which the appraisers themselves have indicated they are qualified to appraise, the appraiser's experience, previous work quality, current workload, and the scope of work. Respondent states that orders that are declined by the appraiser due to a competency issue do not affect the appraiser's rating or impact their ability to receive future orders from respondent. Respondent denies engaging in any conduct that is a violation of Tennessee laws and regulations. This complaint contains insufficient evidence of a violation on the part of respondent. The complainant in this case has failed to show proof of ever being downgraded by respondent for failure to complete an order. As such, counsel recommends closure of this matter with no disciplinary action against respondent.
Well, I heard the complaint. Do we have a motion to accept?
Motion.
Have a motion to accept. Second?
Second.
And a second. Discussion. Hearing none, all in favor say aye.
Aye.
Opposed, like sign.
Item number 6, 2012-013351. This complaint was filed by a real estate agent and alleged unlicensed conduct on the part of respondent. The respondent states this is a department of a federally regulated bank and not a separate legal entity of any kind. The purpose and function of respondent is to coordinate the ordering and review of appraisals and the management of appraisers for residential mortgage loans being considered or made by the bank. Respondent indicated that it does not provide any services to any lender or business other than the bank. Based on the foregoing, respondent claims that it is exempt from registering as an appraisal management company under TCA 6239-404 as being a bank that is subject to direct regulation or supervision by an agency of the United States government. Reasoning and recommendation, TCA 6239-404 states that the Tennessee Appraisal Management Company Registration and Regulation Act shall not apply to a national or state bank, federal or state savings institution that is subject to direct regulation or supervision by any agency of the United States government, or by the Department of Financial Institutions that receives a request for the performance of an appraisal from one employee of the financial institution and another employee of the same financial institution assigns the request for the appraisal to an appraiser who is an independent contractor to the institution. An entity exempt as provided in the subdivision shall file a notice with the commission which contains the information required, 6239-403. Respondent being a department of a bank and not a separate legal entity may be exempt from registering as an appraisal management company but has not submitted notification of its exemption to the commission at any time. Thus, counsel recommends closure with a letter of instruction regarding the requirement to notify the commission of respondent's exemption status according to TCA 6239-404.
Okay, we've all heard the charge. Do you have a motion to accept? Got a motion by Jason, second by Tim Walton. Discussion. All in favor say aye.
Aye.
Opposed, like sign. It's carried.
Item number 7 has two matters, 2012-011-051 and 2012-023-191. valued a residential property in an appraisal report by using inappropriate comparable sales. The respondent sent this office the information that it requested as far as the work file and other documents. However, respondent did not give a detailed response to the allegations by complainant. Recommendation is there are currently 4 similar complaints against the same respondent that are pending a formal litigation, which is set to take place in January 2013. As such, council recommends holding off on sending this case to a reviewer until such time as the other matters against respondent are decided in January formal hearing. Council recommends authorization for a formal hearing on these matters. So basically, we would just hold off sending these.
For these other matters you mentioned, pending formal litigation, we got, is it 3 or 4 that are still outstanding that's going to be brought to us?
I believe that there are 4 that are going to be presented in January at the formal hearing, and then these 2 complaint matters that we just went over, what we do is just hold off on sending those to a reviewer until the formal hearing in January on similar matters. So we would want to go ahead and authorize a formal on these, but not send them out to a reviewer yet. Just hold on to them until these other matters are decided in January.
Okay, so Constable, if I hear you correctly, in January, this individual will appear before us for a formal hearing on these other matters, correct?
That's what we have to have.
And then after we dispose of those, then, if necessary, we'll proceed with the review on these following.
Correct.
To make sure I understand. Anybody else got a question? Okay, do I hear a motion to accept?
Make a motion to accept.
Reverend Phillips, second.
I second.
Nancy Point, second. Any discussion? All in favor, say aye.
Aye.
Opposed, like sign.
Item number 8, 2012017011. This complaint was filed anonymously by email in alleged violations of the Appraisal Management Company law. Staff contacted the complainant via email requesting clarification and proof or documentation of the allegations in July of 2012. No response was received from the complainant after the additional information was requested by this office. The complainant has not provided sufficient information or evidence to effectively move forward with this complaint. This office contacted the complainant to request additional information, and the complainant was unresponsive. As such, council recommends closure of this matter due to insufficient evidence in the violation.
That is heard charged. Get a motion.
Motion.
Tim Walton, accept. Mike Green, second. Discussion. Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Carried.
Okay, item number 9 is a matter that's being represented. So you guys have heard this one before. It's 2012-004791. This complaint was opened by the administrative staff of the Tennessee Real Estate Appraiser Commission after receiving a copy of an email correspondence between an appraisal company and a respondent regarding several requests for appraisal orders. The company alleged unlicensed activity as an appraisal management company on the part of the respondent. However, the company that originally submitted the information did not provide an address for the respondent. Notice of the complaint was sent out to respondent after the complaint was opened via the email address that this office had acquired through the brief email communication between the company and the respondent. The respondent did not respond to the complaint in any way. A previously authorized consent order was sent out to respondent on October 3rd, 2012, consisting of a $500 civil penalty and cease and desist notification. That consent order was returned to this office as non-deliverable on or about October 29th. Subsequently, council contacted the company that originally submitted the information via email to inquire as to whether it had a proper address, phone number, or any additional information regarding the respondent or its location. The company did not provide council with an address. Since this office has been unable to obtain further information from the company, this office is unable to achieve proper service for respondent in this matter. Respondent is not registered as a corporation with the Secretary of State. This office has no proper address or post office box for respondent. The company that originally submitted the information did not send the complaint on any official company letterhead, and the respondent is not registered as a licensed appraisal management company opened the matter at that time to address those allegations.
Everybody's heard the report. Do I hear a motion? Mr. Phillips, motion to accept. Second.
I'll second.
Second, Mr. Green. Discussion. Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Motion carries. Next.
Item number 10, 2012-010641. This complaint was filed by a consumer and alleged that respondent overvalued approximately 8 acres of undeveloped land in the appraisal report. The respondent stated in his response letter that the property was appraised for an estate settlement with a retrospective date for IRS settlement and was communicated as a restricted use appraisal report. He indicated that the division of the property was not an intended use of this report and that the complainant was not identified as an intended user. The reviewer conclusions were that the appraiser failed to accurately analyze the adjustments regarding comparable sales in the appraisal report, as the final value estimate is not supported by the sales used in the appraisal. And the appraiser's lack of adjustments to the five comparable sales used is not adequately explained in this appraisal report. The reviewer found that the respondent has failed to correctly analyze the sales data to arrive at a value conclusion for the property. The final estimate is not supported by the sales used in the appraisal. The respondent has been licensed as a certified general appraiser for 19 years, no previous disciplinary action. Council recommends the authorization of a civil penalty in the amount of $500 to be satisfied within 30 days of the consent order, and a 15-hour site valuation and cost of purchase course to be completed within 180 days of execution of the consent order. These terms are to be settled by consent order or formal hearing. Civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser, thereby protecting the interest of the public.
Everybody's heard the consent order. Just a little bit different discussion. Anybody? If not, do I hear a motion to accept? A motion, Mr. Covington, second.
Second.
Second by Ms. Johnson. Y'all want to have a discussion now? If not, all in favor say aye. Opposed, like sign. Motion carried. Next.
Item number 11, 2012-014531. This complaint was filed by a consumer and alleged that respondent undervalued the log cabin property by communicating a misleading appraisal report. In addition, complainant alleged respondent did not give the complainant a copy of the appraisal report. The respondent states that having very limited sales to work with due to reasons stated in her report, such as the subject county being so small, she was very clear verbally and within the appraisal report about how she based her analysis. The respondent states that she is familiar with her market, current trends, sales, etc., and continues to provide detailed reports in order to increase the level of understanding related to her clients. The respondent states she feels confident that she considered all factors associated with this property and provided complainant with her opinion of value based on the most similar market data available and her experience as a professional within this market. The reviewer found no violations of the universal standards of professional practice within the appraisal report. Thus, council recommends closure of this matter with no formal action.
Do I hear a motion? Mr. Phillips made the second. Second by Mr. Covington. Discussion. Hearing none, all in favor say aye. Opposed, like sign. Carried.
I mean uniform standards, not universal. Sorry. Let's just keep the broader picture. Item number 12 is 2012-012681. This complaint was filed by a consumer and alleged that respondent failed to verify contact information, used inappropriate comparable sales, and undervalued a residential property. The respondent states that the sales comparison approach was employed in this appraisal and that the sales that were utilized represented the best and most recent sales available of homes with similar sites and floor plans as the subject. The respondent indicates that the appraisal prepared was reasonable in light of the current market data. Sales employed were all nearby, nearly identical to the subject in size, and had closed in the previous 3 months. Reasoning and recommendation: the reviewer found that respondent appraiser developed a sales comparison approach, which was the appropriate appraisal method to value the property, and that the selection of comparable properties emphasizes similar age and type properties with similar location and physical characteristics. The cost and income approaches have not been developed and are not required to produce a credible value estimate. However, the reviewer also found that respondent made some misstatements in the summary of sales comparison approach concerning the sites. For example, in the adjustment grid, respondent indicates that the site size on all three comparable cells is 9,600 square feet. However, in the summary of sales comparison approach, respondent states that the site sizes are different but are felt to be equal in value. One of these statements is incorrect. In addition, the improvement section of respondent's appraisal report contains a statement describing updates and physical depreciation of the property. Since only the sales comparison approach is developed, the statement does not apply and should not be included in the report. The property appraised is new construction and there would be no updates. Since the cost approach is not included, the reference to physical depreciation is incorrect. The series of errors is a violation of standard 11C referring to rendering appraisal services in a careless or negligent manner. Respondent has been licensed as a certified residential appraiser for over 10 years and has had no previous disciplinary action. Despite the errors, the reviewer found the appraisal to be credible. Thus, counsel recommends closure of the matter with a letter of warning regarding the series of negligent errors found.
In order to get this open for discussion, do I hear a motion to accept? Jim Walter.
I second.
Nancy Horn, second. Discussion. Mark, this is similar to the one before. We'll have to close tonight. Whether or not you have any comments you might make on this one.
Okay.
Anybody else have any comments? Okay. Hearing none, all in favor say aye. Opposed, like sign.
Okay. Item number 13, 2011030681. This complaint is filed by a concerned citizen and alleged that respondent failed to verify comparable sale data, made adjustments inappropriately or negligently, failed to define the scope of work conducted in the appraisal report. The complainant alleged the errors in the report affected the value opinion in the appraisal for eminent domain purposes of a land acquisition of 12 land vacant lots. The respondent defended his comparable data selections and adjustments applied. He indicated that the value opinion was well supported and no violation of use path occurred. The reviewer conclusions are as follows. The reporting option was not clearly presented in the report. The report does not utilize the proper definition of market value for the type of assignment. The report does not provide adequate identifying information on the subject lots. The sales comparison approach is unsupported and not adequately completed. The reconciliation is not appropriately completed. The reviewer found that overall it does not appear that the appraisal report has been conveyed in an appropriate manner. In addition, the reviewer found that the report does not contain sufficient information to enable the intended users to understand and rely on the conclusions presented. The respondent has been a certified general appraiser for over 17 years with no prior disciplinary history. Thus, counsel recommends the authorization of civil penalty in the amount of $500 to be satisfied within 30 days of execution of the order, and a 30-hour course on general appraiser report writing and case studies to be completed within 180 days of execution of the order. Its terms are to be settled by consent order or formal hearing. Civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser of their right presenting the interests of the public.
Just to get it on the table, ladies and gentlemen, do I hear a recommendation to accept this recommendation? If so, then I get a second, we'll go into discussion mode.
Make a motion to accept.
Got a motion, Nancy, want to accept? I hear a second, second by Herb Phillips, discussion.
I think it's harsh. I would like to see more like a letter of closure with a letter of warning.
Okay. Anybody else have any comments?
Well, it seems to me, I mean, reading this, it's almost, I like had my eyes on it myself to be able to see where I felt like it fell. It almost seems like it could fall either way. So I'm just unsure.
Was this a taking of an entire tract? Was it a partial taking, or exactly what was it? what I'm wondering is, number one, whether or not it was actually a recorded plat or a plat that somebody had sketched out but never recorded, or whether or not this was just a vacant tract of land that had been approved and platted for 12 lots. The reason for asking this is that I am not an attorney, okay?
That's okay.
So my next comment, I don't want you to think I'm trying to practice law, but it's generally accepted in a condemnation that you cannot present unrecorded plats as evidence of it being a divided tract of land. So I'm just concerned, what are we talking about here? Is it in fact, 12 lots just seems like an awful small portion of a larger tract. Maybe it is just a small piece of property with 12 lots. I mean, we could be talking about 100 acres divided into 12 lots. Or we could be talking about 5 acres into 12 lots. I don't feel like we have enough information here, as far as I'm concerned, to make that decision at this point in time. Because it would appear to me that if we have a situation here where it is not a recorded plat, then we've got a more basic lack of understanding of the scope of the assignment, as well as how to process this information from a legal standpoint. So once again, I will abide by the wishes of this commission, but I just do not feel that we have enough data here in order to proceed with a recommendation, and we really need more information on this particular situation.
I agree with the chairman. I think, that was my feeling. If the evidence was that it was just a survey, it had been surveyed for a possible future subdivision or recorded subdivision, I think that holds very little weight. But if it was an actual recorded subdivision with the plat, then of course that makes a difference in the value of the property.
So would you be able to answer that,
Mr. Chairman,
Mr. Johnson?
Mr. Chairman, I agree with Commissioner Bolton and your comments as well in terms of the platting, because that is very critical when you get into litigation standpoint. Also, it doesn't state which condemning agency it was, whether it was a city, a municipality, a county, or state. And with the respondent being a concerned citizen, they may not have had a copy, the landowner's copy of the, if for instance it was a state report, it would have all of the sales data there, the scope of work. A lot of times that's in a master brochure if it's a part of a large project. So, those things coupled with the previous comments, I would agree with possibly deferring.
And another item too that I don't know whether or not it's come into play, but the federal government has a strictly before and after valuation rule, as the state of Tennessee has paid for the partake of that exception. So we got two different legal things going on over here, and I don't know which ones we got jurisdictions over, which ones we do not have jurisdictions over exactly. Well, this plays out, but I still feel I do not have enough information in order to make a recommendation or to. Yes, ma'am.
If you
Before we take a break, just quick, just remember this is probable cause. Legal report's just probable cause, and it's been reviewed by a non-residential expert witness who has expertise in the same area of eminent domain, and would, if it went to formal hearing, they would be testifying to at least these violations noted in the legal report here, the standard rule 2-2s and such. So all of the evidence would be presented to the commission. Probable cause is just, if this is true, is there sufficient grounds to discipline them, and would this be a sufficient settlement of it?
I understand where you're coming from. I think basically what you're saying is you don't want to lay all the cards on the table right now, because we have to serve as a hearing committee, then we got to prove the
Right.
prejudice. And However, we're also charged with making a recommendation whether we agree or disagree. As far as I'm concerned, we don't have enough information at this point in time to either agree or disagree based on the knowledge we have. Now, if Keeling can provide us with some additional information without laying all the cards on the table, I'd be very appreciative.
Another question. Is there a sales comparison course that is less than 30 hours?
No.
It's just not.
There's a 7-hour grid course, but this doesn't have anything to do with certified general, and it would be, if there's, no.
Well, the reason I asked that, if you look at the reviewer's conclusions, it seems to me that 1 through 3 are somewhat subjective. 5 is somewhat subjective. Item number 4 is probably the meat of the crux of the issue to me. And it just seems, back to my original point, 30-hour course is a lot of education for this going forward. That's my
Without revealing all of the information that we do have moving forward, could you provide us with just a little bit more information?
If you just want to have a short break, I can certainly file and see what.
Stay in recess for 10 minutes.
We have to stand.
Okay. All right, we're now back in session.
As far as item number 13 goes, that we were previously discussing, we're going to need to defer that because there's going to be some information missing from.
All right, another question. I've noticed that on this particular set of legal, we do not have who the review appraiser was. Was there any particular reason why they were left off?
Well, I chose to leave it off so that we would make sure it was just revised whatsoever. I mean, that's just something I chose to do, but
Would that give us a better idea, though, of knowing who the reviewer was as to the information you received?
I don't think it matters.
It shouldn't matter.
The non-residential reviewer was Michael Orman.
Okay. That's no problem, I was just wondering. Okay, but we're gonna need to defer this one also, so that's the second one we have got deferred, this one, okay? We need a motion to defer that one? Okay. We'll make them-
Yeah, Ms. Boynton, Mr. Phillips.
Need to withdraw there. Okay, that's withdrawn now. Entertain a motion to hold this one in abeyance until we hear further from legal. Okay. Do you have a motion? Okay. Tim, second? Mike Green, all in favor, say aye.
Aye.
Okay. All right.
Okay. Item number 14, 2012010711. Complaint was filed by consumer and alleged that respondent misreported the square footage using appropriate table cells, misreported property characteristics, and failed to adequately summarize the reconciliation of the value indicators. Respondent stated in his response that the square footage discrepancy was between 15 and 16 square feet and would not significantly affect the value indication. Respondent indicated that reporting the water as being electric was typing error and that the upgrades of the property were considered and included in the appraisal report. The UAD form was confusing for borrowers to understand. Recommendation is the reviewer did not find any violations of USAP after reviewing the appraisal report. The reviewer admits there are a few minor discrepancies in the appraisal, but nothing that amounts to an actual USAP violation. Thus, council recommends closure of this matter with no action.
Do I hear a motion? Motion, got Mr. Covington, second?
Second.
Second, Ms. Johnson. All discussion? Hearing none, all in favor, say aye. Aye. Opposed, like sign.
Item number 15, 2012012601. Complaint was filed by consumer and alleged that respondent undervalued a residential property by communicating a misleading appraisal report and misreported the square footage and used inappropriate comparable sales data. Respondent provided a lengthy response reviewer found that the neighborhood section of the appraisal report lacks sufficient information about the market area. The neighborhood is a high-traffic, tourist-driven resort area, but this was not reported by the respondent. It also found that the improvement section contains some conflicting statements. The report has the subject's attic marked none and finished, and the foundation marked crawl space and full basement. No explanation given. Bill's comparison approach had some inconsistent information and did not discuss any reconciliation of derived and indicated value. Prior sales of the subject property were not properly or accurately disclosed on the form. There were no lot sale documents or reconciliation in the report as support for the site value. The income approach was conflicting as to whether it was developed or not for a rental income producing property. Indications of several errors or copying of another report caused several confusing reporting issues. Data reference to material dated after the date of report indicated that copies and data were added to the work file. Such conclusions constitute multiple violations. Use tax standards 1, 2, and the ethics rule for record keeping section. The reviewer found that the report was lacking in completeness and credibility. The meaning report errors contributed to the lack of report credibility. There appeared to be a lack of apparent relevant data. Appropriate appraisal methods and techniques were not developed by respondent. Without the inclusion of the income approach data, the report is misleading. As such, council recommends the authorization of a civil penalty in the amount of $500 to be satisfied within 30 days of execution of the order, and the 30-hour course on residential sales comparison and income approaches to be completed within 180 days of execution of the order. Terms are to be settled by consent order upon the hearing. A civil penalty should serve as a sufficient economic deterrent while the appropriate education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
Question. These courses and the hours, are they to be towards continuing education or not?
Unless the commission specifically excludes it, they can get up to 21 hours for their continuing education cycle. The appraisers all have to take a seminar, use a path update course. So therefore, if you took a 30-hour course, any courses above 21 would be in excess of the continuing education hours.
Okay, everybody heard the complaint. Do I hear a motion?
Make a motion to accept the recommendation, but amend it to where the course recommended cannot be used for continuing.
Second. Okay, we got a motion, Mike Green, second by Rosie Johnson. Discussion. Ms. Walton?
It sounds to me like this property may have been some sort of bed and breakfast, and that the using approach would be very appropriate and important and valuable in this piece of property. I kind of feel like that would be possibly something that the certified residential wouldn't use as often and probably should have taken much more note of in this assignment. I just wonder if an income capitalization type course might be more appropriate instead of sales comparison, which is probably very well versed in.
Mr. Chair?
Yes.
That course is about half income. If the residential course is sales and income. It's not divided the way the general course is. In the general course, it's sales comparison, and then there's 60 hours of income. The residential course, it's 30 hours of sales and income. And other courses.
Okay, so
Instead of say residential sales comparison.
So it's approximately half of the courses on income.
okay. All right, any further discussion? Okay, we have a motion to accept the recommendation. However, the hours will not count towards continuing education. Is that correct, Mr. Green?
Yes, sir.
Okay, we have a motion, we have a second. Any further discussion? If not, all in favor say aye.
Aye.
Opposed? Motion carries.
Okay, item number 16, 2012004911. Complaint was initiated respondent was previously suspended for an 18-month period by final order in a formal proceeding. Subsequently, a request by respondent to stay the final order was denied, and an appeal was filed. The appraisal report in question includes the respondent's name and signature on an appraisal of the property with an effective date that was during the time the respondent's license was suspended. Respondent remains suspended indefinitely because he failed to pay the assessed civil penalty and complete the requisite education for the order. An investigation of respondent was conducted on or about October 19th, 2012 by the Tennessee Department of Commerce and Insurance. Such investigation resulted in affidavits by both respondent and his father claiming that respondent had no part in the subject appraisal that was conducted by his father. Instead, the secretary at the time was responsible for stamping respondent's name to the appraisal document. Subsequent to the investigation, his office sent out further correspondence to respondent and his father asking for a response as to what steps were taken by respondent to prevent the unauthorized use of his signature on appraisal reports by any employee of the appraisal company after respondent was suspended from the practice of real estate appraising by final order. A response was received by respondent stating that when his license was suspended, he took another job, and when he left his office, it was known by everyone in the office that his license has been suspended for a period of time, and that he was no longer working for the appraisal service. However, respondent also stated in his response that when he left the appraisal service, his password-protected signature was left unprotected for a period of time in case any of the appraisals that he completed before the suspension needed any additional tweaking for those clients and respondent have completed appraisal reports. Reasoning and recommendation. No evidence has been provided by respondent to suggest that he took the proper steps to prevent the unauthorized use of his signature by employees during the time that he was suspended. Respondent admitted that his password-protected signature was left unprotected for a period of time in order to cover past appraisals. Failure to take the proper steps to ensure protection of your signature constitutes a violation of his patent ethics rule under the management section, which states, an appraiser must affix or authorize the use of his or her signature to certify recognition and acceptance of his or her past responsibilities in an appraisal review, or appraisal consulting assignment. An appraiser may authorize the use of his or her signature only on an assignment by assignment basis. An appraiser must not affix the signature of another appraiser without his or her consent. And the comment section states an appraiser must exercise due care to prevent unauthorized use of his or her signature. An appraiser exercising such care is not responsible for unauthorized use of his or her signature. Thus, counsel recommends the authorization of the consent order authorizing revocation of respondent's real estate appraiser certification be settled by consent order upon hearing.
You've heard the recommendation of council. Do I hear a motion? Either who's able? Motion by Tim Walker to accept. Second? Kevin. Seconded. Okay, now discussion.
Is his license currently suspended? So this happened while it was in suspension. So this would be, recommendation from council would be just to go on and revoke it.
Yes.
Even though he's not, understand.
Any other discussion?
I didn't get who got the second.
I made the motion.
Mr. Phillips made the second.
He just raised his hand.
That's the question. You can put me down for a second if you need to. Anyway.
Okay.
Someone
Right.
should second it.
Mr. Covington made the motion. Mr. Johnstone made the second. Now in discussion. Unless Mr. Johnstone asked the question. Okay. Now, any further discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Council.
Okay. Item number 17 has 4 matters: 2012-022-981, 2012-022-591, 2012-02-0561, 2012-02-3031. The first 3 complaints were opened against the AMC, alleging that respondent failed to pay numerous appraiser's fees. Each complaint is filed by a different complainant. One complaint was opened against the AMC by the administrative staff of the Tennessee Real Estate Appraisal Commission upon receipt of a notice of cancellation of a surety bond on or about October 5, 2012. Respondent has not sent proof of a current bond to this office. Respondent filed a response stating that the agency has started negotiations months ago to be acquired by another company. However, because of unintended delays and setbacks in this transaction, respondent has fallen behind on payments. Respondent claims it does not have the necessary capital with which to pay the appraisers, but saying it would make every effort to pay the appraisers as it obtains funds. Recommendation is council recommends the authorization of the consent order authorizing revocation of the agency's registration and to require proof of payment of all unpaid invoices in the above referenced complaints, along with a $10,000 civil penalty prior to any future application for registration as an agency in Tennessee to be settled by consent order or formal hearing.
Question. It said that they were in the process of trying to sell. Did I read what that had fallen through? Okay.
We don't have any evidence that ever went through.
So would it be appropriate to say if they ever, that they would not be allowed to practice again in the state of Tennessee if we know who the principals are?
What would your recommendation be on that?
Mark, did you have?
It just said the recommendation appears to have a $10,000 civil penalty
Yeah.
prior to any future application. So if they came back and tried to reapply, they would have to pay that. Is that correct?
Now, does that apply to the organization or the individuals? I mean, if the AMC is an LLC and it's defunct, but then the principals that organize the LLC come back with under another name, then they may or may not be subject to the $10,000 penalty. But I don't want them to find a loophole to come back and avoid the penalty.
It's the inherent flaw in the registration process is that you're registering a company, not people. People will change. The companies can just close their doors.
And of course, this is to require proof of payment of all unpaid invoices. How does that happen?
Well, I mean, it would just have to be like it says. They would just have to, before they make the application again, they would just have to show that they paid all the invoices that we have record of that have been.
That we have record of at that time. And we send out to the appraisers that I know that what I'm wondering about, do we have some appraisers out there who don't work for this AMC company who has not filed?
Oh, well, probably, that I don't know.
And I don't know, so
Yeah, all we know about is
Sure.
are the ones that we have record of in the file.
okay, understand. All right, we've heard the recommendation and everything, screen.
Just the way this is written, it almost looks like it's the $10,000 penalty has some relation to their future application. Is that what we mean? Or do we mean to fine them $10,000 regardless of a future application?
Well, I mean, the way that it's written, you're right, we would mean that they'd have to pay $10,000 prior to applying in the future. We can reword that to state.
It's exceptionally unlikely that if we could get someone to agree to the revocation, a controlling person to agree to the revocation, they would also pay $10,000 and pay all the invoices. It'd be more likely if they were trying to reinstate a license that they would pay the appraisers and the penalty. Probably this is going to go very similar to the fashion that we just, the formal hearing you just heard against appraisal law, where the controlling persons disappeared, the company shut its doors, thousands of dollars were owed appraisers, and the company was just gone. I don't know how to chase.
I don't either. But this rings a bell. Have we had the same company complaint filed on that same company previously that we've heard?
It's a different company.
Different company?
It's a different company.
Okay. No problem. I just kind of had the same ring to it, you know.
The allegations are similar to the
Yeah.
one that the
Right.
hearing heard that
Yeah.
happened against appraisal law. So
Right,
that
that's right. Wonderful.
thousands of dollars are owed and
Okay.
there's no one to pursue.
Okay. It's just on the books, so in case they do want to do something, we got something there to kind of.
Right. And this may not be as big of an issue in coming years because there will be a national registry of appraisal management companies moving forward, and discipline would be reported. And this discipline would be reported.
Okay.
Mr. Chairman,
Yes.
this is just for point of information or clarification. In the disciplinary history, there's 4 pending cases. Those are in addition to the 4 that we're talking about here.
So it's only
And there, yeah, I see. You've got maybe
Well,
are those they're not cross-referencing each other, are
well, some of them are the same as what's in the complaint.
they? So I got 81, 91, 61, and 31, which is in the complaint. And then down here I've got 98, 59, 56, and 03, which would.
They're the same.
Yeah, these are all the same.
Okay,
She
so
just added the number 1 to it for the legal file.
Sorry, that's probably confusing. I apologize.
okay.
They are the same. though.
Oh, they are. Okay,
Yeah.
that's all I wanted to clarify.
Okay. Any other comments?
Let me ask you, this has obviously happened before. Is there anything that this commission can do to, that there needs to be legislation in place, and we're a rulemaking body, but we can suggest legislation to amend some of these things to prevent this kind of thing from being an ongoing problem and kind of a revolving door for AMCs to continue to practice this way?
Yes, and this is one of the things that I wanted to be part of the discussion for later during the director's report section to discuss it. But remind me again when we discuss the CFPB requirements, and then I'll elaborate further. I hate to take away from the legal report to talk about federal laws and how we're going to effectuate change. Let me defer that answer.
You restate the motion.
The motion is for the council recommended authorization of the consent order, authorize the revocation of the AMC's registration, and to require proof of payment of all unpaid invoices in the above referenced complaints, along with the $10,000 civil penalty prior to any future application for registration as an AMC in Tennessee, to be settled by consent order or formal hearing.
Do we notify staff at this stage? They're paying the $10,000 penalty.
Well,
It
I
doesn't
think we
matter
discussed it, Jason. I'm too sure that we actually amended the,
I think there was discussion
I don't think we
about
actually made that.
You're asking to amend it as the $10,000 of penalty regardless of any future application.
Correct.
Yeah.
Put a period after the word penalty.
And I may have missed it, but I didn't actually get a motion and a second on this one.
One question, this is essentially all we can do as a commission in this situation, given the current legislation we have to operate by.
I am happy for anyone else to look at the laws and rules to see if you interpret it differently, but I don't know. This is new to me too. I'm not going to say I know everything about this. This is very new to me, licensing a company. I know I'm an appraiser, so I understand how to find appraisers and what appraisers do, and it's pretty easy for me to understand discipline that affects appraisers, but it's really hard for me to conceptualize how to chase a company. We don't license the controlling person. We don't license the owners.
Well,
I don't know how to
essentially,
make
if they're operating as an LLC, there's a firewall there against pursuing the principles. But it would be nice if we had some sort of a national database that could flag these principles for future, just like we're looking at a DUI wife or someone applying, we should be able to look at the past history of violations and operating AMC as well.
I think that's one of the reasons why the National Registry for Appraisal Management Companies has been delayed as much as it has, is because they're wrestling with the same concepts, like how do we wrap our arms around this? You know, how do we, you know, it's easy to create a registry of individuals, but how do you create a registry of companies with individuals in it? There's a constantly fluctuating thing. And then, as a subcomponent of it, they're also anticipating the payroll. Jason could talk more about this, but not only all of the people who work for the appraisal management company and own the appraisal management company, but the payroll of appraisers that appraisal management company administers is somehow going to have to be connected to that national registry. Is what they're anticipating. And I just shook my head through the whole conversation at the national meeting. It's like, oh my God, I don't know how we're going to do that.
Okay, all right, I heard somebody say just put a period after that. What do you, exactly what were you suggesting? Recommending to amend this? The way I see it, we don't have the money now. They probably don't have the money since they're out of business. And we say, okay, if you ever do try to get back in business, you're going to have to pay us $10,000. We're also going to require proof of payment of unpaid invoices. You know, it's like getting a judgment against me for $1 million. Well, I'm selected collector. I mean,
And they don't have sureties on it either.
yeah, and it's so consequent. I don't know. Probably it's the best we can do.
Mr. Chairman,
Yes.
you know, being on the AMC side myself, I mean, this kind of stuff right here just infuriates me. You know, and all the stuff about selling the business and, you know, future, you know, may sell, may not, we got things mixed up. The fact of the matter is, the appraisal management company was paid before they ever sent that assignment out. They had that money for that appraisal.
True.
So I don't know what could be done. We can't go chase the money. She's right. I mean, we can't go do all that. But whatever we can do, I think we need to do it. This stuff just makes my blood boil.
Well, the problem is, Jason, the way I understand it is, if it's a company we can't really communicate with,
Right.
and they have no capital, then it kind of puts us into the point of, okay, we can't do anything with you now. But if you ever want to come back in again, we're going to block you, and you're going to put up some money. That's the way I understand it. Anybody else got another understanding?
They're just opening up that differently.
Basically, right, they're gonna come back after this company, which they undoubtedly will.
No.
They'll just, they'll develop another, they'll file as a different LLC and they'll come back with no record.
Just like
You have the authority to fine them $1,000 per violation per day, and you did that in the appraisal law plan. And I have to say, the feds listen. I believe appraisal loft people are being investigated, because there's a number of states that took action exactly in the same mechanism. That, you know, they did what you did, which was had a very large civil penalty against a company that they couldn't get their arms around. But the federal authorities are looking at that, is what I heard from the conversation at the Arrow meeting. So sometimes what's said here is heard on a national level.
Will this be reported to the federal register?
Oh, yes. Ultimately, right now there isn't a national registry to report it to, but the Dodd-Frank law is in effect, and so the national registry will have to be caught up with the national registry that exists.
Well, we need to go ahead and move on, so.
I'll make a motion.
Okay, second. Motion, second. All in favor, say aye. Okay, opposed, like sign. Go ahead,
Oh, we don't know what the motion was on that.
I don't think you wouldn't notice that.
continue. Well, we'll try to slide it by. I thought we were approving what you recommended.
No, I want a period of the word penalty.
Okay, well, do you want to eliminate the rest of that sentence?
Yes, sir.
Okay.
So we need to get a motion on.
We need to,
Well, we wouldn't be eliminating the rest of the sentence, we would just be eliminating from prior to Tennessee. It would still say to be settled by consent order.
Okay.
So just for my clarification, I apologize. So essentially what you're doing is presenting them with a consent order for revocation and payment of $10,000.
And
All unfigured.
they would be
And all
refunded.
unpaid invoices. But if they close and then reapply, you're not getting any penalty on them reapplying.
But they would have to be approved, correct? If they were to reapply.
They are reapplied in the same name.
Right, but if outside
That would be
applying
so
the same
weird.
name, there's nothing to do anyway, correct?
I think that's the regular procedure.
I don't know how we tie it to each other. They're not licensed by their social security numbers like Appraiser times.
No, I say if they reapply, it's they, because it is a
Right.
I understand. But at least this way, there's a $10,000 penalty. I'd rather, if we can find them, they'll have to pay it. When, silly question, but when you revoke, is that just says you're revoked? It doesn't have any kind of.
It would be a violation.
This is a great
I will make a motion to put penalty after the word. Put the period. Eliminate the word. The word.
Or prior. So agreed. Council recommends the authorization of consent order authorizing revocation of the agency's registration and to require the payment of all unpaid invoices in the above referenced complaint, along with a $10,000 civil penalty to be settled by consent order upon hearing. If that's
That,
That's it.
that was exactly what we said.
You didn't get that the first time, I'm sorry.
The motion was Mr. Green, confirm, and the second was Mr. Phillips, confirm. All right.
Want to vote?
Yeah, we need to vote.
All in favor, say aye.
Aye.
Opposed, like sign. Okay.
Item number 18, 2012001291. Complaint was filed anonymously and alleged that the respondent communicated a misleading and unsupported value opinion. The complaint included 2 reports on the same property completed by respondent on September 15, 2010, and September 18, 2009. The respondent stated in his response that the subject property appraised consisted of vacant land that was planned to be developed with a condominium development. The developer projected the construction of the clubhouse and other amenities of this development, but the respondent was never provided any construction plans respondent relative to similar complaints on a credit performed during the time period after the date of the subject appraisal. Those complaints included allegations that were the same or similar to the allegations in the subject complaint. All of the prior complaints were resolved by one agreed order which imposed a probationary period, payment of a civil penalty, payment of costs, and extensive hours of continuing education. The respondent has completed all terms of the agreed order. Had this complaint been received prior to the execution of the agreed order, the complaint would have been included in and resolved by the agreed order. The respondent has had no complaints filed against him regarding appraisals performed after entering into the agreed order. Because this matter was received by the administrative office more than 5 years after the appraisal was prepared, because the respondent agreed to and completed extensive continuing education, paid civil penalties, and paid costs for the same or similar allegations since the time the subject appraisal was prepared, and because this matter would have been included and resolved by the prior agreed order had it been received earlier, it is council's recommendation that this complaint be closed with no further action.
We have the recommendation of council. Do I hear a motion? Mr. Phillips makes the motion. Mr. Covington seconds it. Discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like signs.
Item number 20-2012-016-931. This complaint was filed by a homeowner and alleged that the respondent communicated an appraisal that contained numerous errors that caused the appraisal to be misleading. The respondent stated in his response that he received 3 addendum requests from the management company and that he promptly responded to each addendum of the appraisal. Any additional issues that the homeowner was disputing may have been presented to her lender but were not presented to respondent until notice of the complaint was received by him. Respondent states that the issues that the homeowner has presented are descriptive in nature and have not adversely impacted the property or anything of value. Your conclusions are as follows. The appraisal report fails to summarize and support the following opinions and conclusions. Number 1, opinion of effective age and remaining economic life. Number 2, opinion of external obsolescence regarding location near railroad tracks. Number 3, opinion of site value. Number 4, opinion of adjustments in sales comparison approach. Number 5, opinion of exposure time. The appraisal report fails to summarize the opinion of the highest and best use, both as improved and as vacant. The appraisal report fails to state whether prior services have been performed on the subject property within the previous 3 years in the report certification. The appraisal has sufficient violations so as to be considered as having been performed in a careless and negligent manner. The work file submitted to the review appraiser did not contain a true copy of the original appraisal report submitted to the client. It only contained a revised copy. It also did not contain any data regarding list comparables or any file or any data to support the site value opinion. The reviewer found several violations in his past and subject appraisal report, along with multiple agent mistakes, such as mistakes in sales comparison grid, mistakes in the comments to the sales comparison approach, and lack of documentation to support the site value opinion in the work file. The reviewer suggests that such violations and mistakes can cause the appraisal to be as such, council recommends the authorization of civil penalty in the amount of $500 to be satisfied within 30 days of execution of the order, along with a 15-hour course on residential report writing and a 15-hour national youth path course to be completed within 180 days of execution of the order. These terms are to be settled by consent order of formal hearing. The civil penalty should serve as a sufficient economic deterrent while effective education to assist the respondent in the market and the order of obligated in the interest of the public.
We've heard the recommendations of the council. Do I hear a motion? Jason Covington makes a motion to accept. Second?
Second.
Second by Nancy Moore. Nancy, I'm sorry. Close. Johnson. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, like sign.
Item number 21-2012-025311. This complaint was opened by the administrative staff of the Tennessee Real Estate Appraiser Commission, failure to submit biannual certification as required by the laws and rules of TREC. On December 3rd, 2012, respondents submitted the appropriate biannual certification as requested by this office.
motion? Motion to accept at this point. Second? Second by Jason Covington. Discussion?
What is the biannual certification?
Going back to those complaints to check, apply with use pad, getting back to this place to check for. Gosh, there's a bunch of, there's a series of things that they promise on the test to certification. It's under,
That same set of rules?
I'll send a reference it. System and process of verification of licensure of the individual, system and process of verification, making assignments, periodic appraisal review, and maintenance of records.
So, well, can we bring this up later?
Yes. Yes, sir.
Okay. All right. Any other comment, discussion? Hearing none, all in favor say aye. Opposed, like sign. Motion carries. Next.
Item number 22, 201202.5.31. Complaint was opened by the administrative staff of the Tennessee Real Estate Appraiser Commission for failure to submit biannual certification as required by the laws and rules of the Tennessee Real Estate Appraiser Commission. On November 29, 2012, respondents submitted the appropriate biannual certification as requested by this office. Since respondents submitted the appropriate certification, council recommends this matter be closed with no further action.
Let's heard the motion. All in favor? Do I hear a motion to accept? Phillips motion to accept. Second. Mark Johnstone.
I'm sorry, who was the motion? Thank you, sorry.
Second was Mr. Johnstone.
Johnson, all right.
We need to get his name on the record. Mr. Johnstone has been very helpful in the second motion. Give Mr. Johnstone. Any
John
discussion?
Stone did the second?
Yes.
Oh, I'm
Any-
sorry, I got that wrong.
Any discussion?
Oh, Andy, all right.
Right. Any
John
discussion?
Stone. Can you two not sit next to
Yeah,
each other?
really, you put us here.
If I slur Mr. and Mrs. close enough, she'll never know what I was talking about. Okay, all those in favor say aye. Opposed, like sign. Next item on the agenda is the director's report.
Would you all like a break, or do you want to dive straight in?
Well,
That's all entirely up to you.
let me ask you a question.
Don't say it, you don't need it.
How long do you think it will require for the director's report? 30 minutes, an hour, what?
I would hope that we'd be wrapped up in less than an hour.
Okay, so it'll be about 20 minutes to a point.
But I'm happy to proceed. You can at any point say it's time for lunch, or it's time for a break, or you can say that at any point. So it's up to the commission to set that. I just want to make sure before I started, at least I said that.
What is the commissioner's wish on this?
So we make an
Okay. All right, well, the first thing I'd like to say is I'd like to recognize that Keeling did an amazing job. She's only been with us a couple of months, and she did an incredibly lengthy and detailed legal report. You know, for someone who does not have an appraisal background and
Done very well.
has a gigantic stack of complaints that was dropped in her office. She's done a terrific job, so I'm very impressed.
Before we move any further, the chairman does need to make one quick phone call. It'll take about 2 minutes on this. Y'all just bear with me.
So we're taking a break?
5 minutes, yes.
5-minute break. Yes.
I bet he's gonna have some.
We're now back in session, so please proceed.
Thank you. I did put the director's report on your iPads for your viewing pleasure. Some items for notice. Human Resources Department has opened up our staff positions. We have one position open currently that people had the ability to apply for up until last week, and we should start interviewing for the jobs beginning in January, so hopefully the staff shortages will be coming to an end. The laws and rules will need to be amended for 2015, which I'll discuss more in just a moment. Good piece of news, I always like to throw in some good news. The newsletter's done. I emailed it to Mr. Green for check. He wrote a newsletter article, so I gave him first option to revise. I'm going to give it a couple of days just so in case he goes, no, stop. But I should have it by the end of this week published to the website and then out on the listserv. There's an article by Mr. Green. There's an article by, I'm blanking on the guy's name, Steve, I want to say Barbary,
Yes.
something like that,
Regions Bank.
with Regions Bank on best practices for sales comparison approach. I reprinted an article that I wrote on identifying significant appraisal assistance pursuant to Mr. Hall's recommendation that we had some issues on that and we needed to revisit the issues with the trainees. And there's a notice on the front of the two new commission members, Mr. Johnstone. I'm sorry, we typed your name wrong on your tag there.
That's the first time.
It was really short notice. And Mr. Covington, so you'll be on the front page of the newsletter. And then the other thing on the cover will also be the 2015 criteria changes, the bullet points that will most affect Tennessee licensees, as best I can summarize them. And item 4 on the notices is that at the very next commission meeting, the subcommittee members, our federal auditors, will be here. So I will be juggling a lot of balls in January. They're already requesting documents and reports. Everything's ready for them. I've compiled all the reports. I'll be communicating them to them this week, and then they will start selecting specific things they want to audit, like complaints, applications, renewal forms and documents. They'll audit all of that up to and during the 3 meeting dates that will be here. We have a formal hearing scheduled at the exact same time. So the commission is scheduled for a 3-day formal hearing. We need to have quorum. So we can't have the formal hearing without quorum. We can't have a commission meeting without quorum. So
What days are those?
14, 15, 16. So if you are not going to be able to attend all 3 days, you need to let Mr. Hall and me know. You can't attend one day and not attend the next day if you're going to vote on the formal hearing. That's not how hearings work. So it's very important that you consider that it's a formal hearing, not just, small items of business that only take, a little while to hear. It's going to be a lengthy process. I don't know that it's going to take all 3 days, but it certainly will take 2. So for sure, book the 3 days. I have to allow enough time in case it gets very contentious. It may take 3 days. And there will be 3 ASC members attending. They're very nice people, and I have no problem with them sitting in our formal hearings or anything like that. They're allowed to by law anyway. So they will be here. One will be reviewing documents, and one will be attending the commission meeting at all times. And there'll be a third one, and I don't know how they'll split their duties on the third one. They're training a new person. Usually there's only 2 auditors, but this time there'll be 3.
That's January 14th, 15th.
January 14th, 15th, 16th. Whether or not,
guess it's
If for
not
some
that-
reason it settles, I will let you know the formal hearing. If it settled before the hearing, I will let you know as soon as I know.
They're from the appraisal subcommittee.
The subcommittee, but the subcommittee will be here either way unless there's some unforeseen event that prevents them from being here. But whether or not there's a hearing, the subcommittee plans to be here. Usually they ask for 15 minutes of the commission's time just to present their findings if they have any at that time. If not, they will send a letter and I will present it to the commission at a subsequent meeting.
Are they appraisers?
No,
Are they bankers?
no.
Okay, what are they?
They're employees of the federal agency. The subcommittee members themselves would all be,
Appraisers and bankers.
there's only one appraiser on there, and actually it's been, I think since it was first initiated, the subcommittee was first initiated, I don't think that there's ever been an appraiser member, but Peter Gillespie from HUD is an appraiser member, and it's the first one ever that I've heard, I can recall, and I can recall back pretty far. So that's actually pretty big news, and they have 2 new members. The CFPB is on this appraisal subcommittee now, and also the FHFA, Federal Housing Finance Administration. So many acronyms. So that they sit like a board, but so consider them like you, and then the members who come out and audit us are like the staff of the board. So like my staff out here, they come and look at the documents, and then they act as the eyes, and then when there's an issue, they present it to the board and say, hey, Tennessee has these issues, what do you think we should do? They have more authority now. The Dodd-Frank law gave them more authority than they've ever had before. Before, their only disciplinary action was the proverbial off with your head, which was derecognition of a state, no longer allowing us to license or certify appraisers, which is pretty draconian, going from nothing to you can't have appraisers in your state. So that would mean that all the appraisal of federally related transactions would have to be done by out-of-state appraisers. A couple states have come in danger of it, but no one's actually ever been derecognized.
Mike, I reckon you and the answer would be okay. Y'all can operate in Virginia, right?
Okay, on the first page of the director's report, there's your budget information for the last 2 years. 2 years budget closed. The adjusted balance shows what we have in our savings, essentially. And on the separate 2013, 12-13 is the expenditures thus far this year and the revenue generated thus far. That includes, please note, that includes both the appraiser and the appraisal management companies. So the number, the bar graph that shows below, it shows an upswing, but that shows we also had an entirely new profession added to the Real Estate Appraiser Commission, so that would be a natural reflection of that. On the next page.
Can I ask you a quick question? please?
Yes.
So would I be correct in assuming that what we took in for the 2010-2011 fiscal year and the 2011-2012 fiscal year, as far as total expenditures, revenues, those two would be pretty much equal moving forward as a basis?
We have high and low years. That's one of the reasons why that I think the bar graph below shows is helpful. Just kind of shows you our high and low years. 2009-10 was an exceptional year. A lot of that came out of the increased requirement changes.
we have a renewal cycle that's high and low, since you're on a 2-year license cycle.
Who has to approve our expenditures?
Our expenditures, regulatory warrants.
So if we want to spend some money, we have to go to them.
Yes.
Okay, this should be based on a budget that you would prepare.
Yes.
Mr. Phillips and I had some suggestions for that.
Was that the Caribbean vacation?
That was the first meeting.
Oh.
No, the second one was, I'm not gonna say we were worth it, but I did think we deserved more than $50 a day. I think the cost of inflation, nothing else since 1990 has gone up a tad.
That would have to be changed by statute, so you will have to talk to your state representative.
But you said you had a budget.
I do, but the commission member is a specifically identified statutory allowance, and that's all I can do. I wish I could change that, but you would have to talk to your state senator or state representative to see how that gets changed.
Which, although the law is coming up for review, right? We do have some new laws that we're going to be asking.
Yes, I think that would be, yes, I think that's within the power of...
Had there been appropriate time to make that recommendation or ask for that recommendation?
I don't know if it's done as a whole, but yeah, I think, that would, it'd have to be done through the lawmaking process, and I don't know if it's all of reg boards that have to get changed, or if it's just the commission that gets paid that much.
I have no idea either, but I would like it to be put for discussion and we get ready to draw up our laws in order to take to the legislature, get them to approve what we suggested. I do think that would be appropriate.
It does seem a little minimal, and especially given that they also take taxes out of it too, out of your $50 a day.
And if it helps anyone, I don't talk to you.
$200 a day? That's nice. Talk to Larry. Your complaint pattern shows on the next page. Changing the subject.
We noticed.
Changing the subject. We're about normal for the year. We'll probably get a few more complaints in, so it'll be a high year, but high for normal. I actually expect in the next couple of years it'll get a little higher as the mandatory reporting that came of Dodd-Frank law is implemented. The law is in effect now, but changes, federal law, especially anything that affects the banking institutions, I think implementation is a slow process. So the banks have to, they're mandatorily required to report violations of use cap. I think they're all sort of just figuring it out on how to. And they're also, I think a lot of them are waiting for the appraisal subcommittee to finish their complaint hotline. And the hotline was supposed to be up like 6 months ago, and it is not up yet. So,
We need to bring that up. Guarantees, maybe also.
I don't know. I think it would be a tantamount to saying to the to my office assistant that, I think you should change the law. She'd just look at you and shake her head like, 'cause the policy managers don't have anything to do with it. They're just auditors. But I mean, I didn't call them just auditors, but for the record, I didn't call them that. On the next page, the breakdown of your license numbers: certified general 726, certified residential 974, still the highest category. Licensed appraisers, still the smallest category, and I think it's going down a little bit. 127 registered trainees, 243. Keep that number in mind. And a total from the above is 2,070. Appraiser courses, we had 347, and you just approved, actually I think 10 more. So we added one at the last minute after I finished the director's report. 221 temporary permits, and we have 100, and as of this report we had 156, but one pending, but we now have 158, so we had one after this. So, and then we just approved one month on. And we have 137 inactive appraisers. Again, the subcommittee is coming. I attended the Aero conference in Washington, D.C. in October. To give you some updates on that. First one is I did get appointed as vice president of Aero, which means that in 2015 I will be president of Aero, barring no unforeseen circumstances like me running away like a coward.
That'll be next year.
2015.
You'll be president in 2015.
Yes, first you're president, or first you're vice president, then you're president-elect for a year, and then you're president for a year. So it really means like 2 years of being president. You have to do all the jobs twice. But it also gives you a year in training with somebody else doing the job. So it's helpful. Sherry Bren from South Dakota is the current president of Aero, and Larry Disney from Kentucky is the current president-elect. Both of them have been past presidents of Aero, so I have a lot of leadership history ahead of me, and so I'm confident that by the time I am president, I will have all the tools I need to get the job done. In 2015, Aero will be in Nashville. They'll hold their spring conference in Nashville. I coordinated that with my agreement to do this, so that you all will get the opportunity to attend an Aero conference.
Where will it be held, do you know, at this point?
The meeting coordinator is working on contracts. He's going to solicit several bids. The space needs, Aero is very space intensive. They need a lot of meeting rooms for breaking that down into individual groups. So they'll be contracting, essentially doing that RFP process with several of the hotels in the area to see who can meet the needs of it. I'm not sure which one it will be yet. We'll probably know by next year.
Do y'all work on a calendar year or fiscal year?
Calendar.
Okay, so consequently, come January, you will be the vice president.
I am vice president
Now.
now.
So,
Well, the meetings are in October and in April. So that's when the elections are held.
in April?
Yes. So they just had a meeting in October, and that's when they had the elections for officers. Try and get me ousted, Mr. Hall?
No, I'm just trying to figure
It's
out
only been 2
whether I should
months.
be referring to you as Madam Vice President now, or wait until to January. I just won't clear.
I'm only vice president of Aero. I'm not vice president here.
You're still a VP.
Okay. Okay. Well, it is an honor, and it will give us a lot of political context and help, I think. And it sort of is a feather in the cap of Tennessee, so I...
Well, we're very proud of you. You're taking an active part in that.
And I want...
And we will support you.
I'm going to do everything I can to get as many of you involved in the process as possible, and I'm going to try and get more travel approved for...
Us?
Yes, for you guys. I tried to this last time, but unfortunately some problems with Edison. The approval did go through, and it was approved by powers that be, but the technology did not, and so therefore they would never have paid it. And I didn't want some, Mr. Green and Mr. Covington to pay for it out of their pocket and then not get reimbursed. So it was not the state didn't say you could go. It was the state wasn't going to pay it
So,
because of a...
so now we're going to be trying to revise.
I will get it in earlier, and there won't be future hiccups. Some of it was because Mr. Covington was so recently appointed that he just wasn't in the computer system yet in time to get his travel approved.
Well, once again, the County Big Commission, we're very proud of you. Thank you for taking an active part in representing
All right, well, the biggest thing for 2015 that I want to discuss is the fingerprinting and background checks. The one thing I need the commission to vote on today, I need to get your mindset on whether or not we want this requirement. It is going to have to be a decision of the legislature, but the legislature will most likely defer to the will of the commission on, because you're the professionals and you know what's best for the profession. Does the commission wish for the background checks to be done just to initial applicants? That would be trainees and persons applying to upgrade a license, like from licensed to certified residential or certified general. Those initial applicants. Or would you want it to be done for all appraisers, encompassing everybody, which would mean we'd have to set it up so that people would have to do it on their renewals. So
I'll of course, defer to the wishes of this commission in answer to that question. However, when you look at the cost and the expense of trying to go back and fingerprint on a background check on 2,070 people, it's going to get rather expensive, I would think. And we've already all signed, we made applications for appraisals, that we not signed things that said we had not done anything wrong, or if we had, we had to make you aware of it. So we'd be perjuring ourselves if we did not tell the truth at that point. And I'm thinking that we just, grandfather in like we've done so often, those that are already in the system, and just start making a requirement, because I don't like the idea of going back and doing it, because the cost and logistics involved, to me, it would just be overwhelming in order to do that.
the cost would not be directly related to the commission. The cost the cost will be transferred to the licensees. There's several ways that we can accomplish this, and I'm investigating some possibilities. I've never done this before, and this is another, besides the agency thing, which is a small undertaking. The fingerprint and background check will be done by the TBI. Also, PSI has an operation to do that as well, like what they do when they get testing. When you sign up to do a test, they have the technologies to do the fingerprint and background checking. When you sign up to take the test, you can just put your hand down on a machine. Digital fingerprints and background checks. There's another option that I'm going to meet with someone on next week, which the mortgage licensees, and that's part of the package I gave you. There's a system called the National Mortgage Licensing System, NMLS, and so all of the mortgage licensees have to get fingerprinted and background checked, and so they already have a mechanism in place to do it. And for $130, $100 for each company, $30 for the individual, they do the background check. They can be done once or periodically. The fingerprinting only has to be done once, but the background check you can do every renewal, because the background check is only good for the day that it's done. So, as you said, when you initially applied, you filled out an affidavit saying you didn't have any convictions for felony, blah, 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 and that may have been true when you filled it out. But at the same time, there's no actual disclosure obligation after the fact. So if no one turns you in and you didn't tell anyone that you had a felony, and I know you didn't, but I'm just using it as an example.
Are you certain? Quite certain?
I'm not quite certain, but if an appraiser had a conviction, there wouldn't be a way to notify us, or a requirement to notify us. It doesn't. Our laws and our rules do not currently have a requirement. The real estate has a requirement that you notify within, I think it's 30 days, it might be 60 days though, of any conviction. Well, we don't, in the appraiser laws and rules, don't have a requirement that they notify us.
Question, would we be better off putting that in? If you are convicted, you ought to notify the local board rather than saying that you're going to have it come in every year for a background check, or maybe have a background check every year. I'm just concerned with the logistics of trying to get all this stuff done.
I am so concerned with getting all this stuff done. No one's more scared than me.
Good morning.
A couple of questions, Director Avers. It's mandatory on new licensees and applicants and optional on existing licensees? Is that the way it's?
Yes. Each of you were given a copy of the Appraisal Foundation's Real Property Appraiser Criteria. I'm sorry, I have to use my glasses. My eyesight has gotten especially bad just lately.
Can we take these with us?
Yes, those are yours. However, I would appreciate it if you would not lose them, because I had to make a special request of the AQB to send these to us. Otherwise, I have to print them off myself, and they're not going to be as fancy and pretty as these. They sent these to us for free.
Very nice.
Yeah.
How much do we pay them? Just remember that old economic principle, there ain't no free lunch. Somebody's paying for it.
That'd be great. Sure. This is an open forum, yes. Okay.
Take a day off from work.
I had to plead with you to watch the video, and I'm only 60% sure you did.
You suffering from insomnia?
We have a special guest in the audience, and I wasn't certain if he would speak today, but he actually, I've been notified that he has some special knowledge on this fingerprinting stuff that might actually be helpful. So if the commission would allow it, I'd like him to be given an opportunity to speak.
My name's Charles Snyder. I'll get closer to the microphone. I'm Charles Snyder. I'm one of the liaisons for the department, so I serve as your representative for the rest of the boards and then the other parts of the department in front of the legislature to the governor's office. So I, the wisdom that you shouldn't serve two masters, I have 4 dozen. So it's always fun. But I would say on this decision, really, I think focusing on the policy implications of this, there's a federal requirement, how you want to step that through. Don't get too bogged down in the logistics of the actual fingerprinting, because we do this for about 24 different licenses, so we already have sort of some systems in place where people can go in to get fingerprinting. Really, it's moved away from what you think of the ink stamp cards to actually digital machines now. So you go to a certified place, whether it's one of the TBIs, Department of Safety's, or PSI that we're plugged into for different ones. Basically, you prove who you are, your identity, through your driver's license, your passport, and other things, and are filling out a piece of paperwork. And I'm doing this for the appraiser board, and we are already sort of tied into a contract with them to do this. They scan, no different than sort of a fancy copy machine where they scan your fingerprints, and it goes in, and then they're in charge of the chain of custody and come back to Nicole and Keeling with the report on this is how the background check ran. So the logistics, while they seem a little tricky, we do already do this in a variety of different things. So and for your next meeting, we can have that information ready for you to sort of break down the costs and on our contracts, plus, as Nicole mentioned, what some of the mortgage brokers are doing and figuring out the efficiencies there. But I think the federal requirements from Dodd-Frank are really where we need your wisdom in this area, because by the time we get to 2016, we certainly want to be in compliance. So if anybody's trying to get a VA loan or FHA loan or anything like that, a Tennessee appraiser can do that appraisal. Personally, we border 8 states, and I don't really want people coming up from Jackson, Mississippi, or down from Louisville, doing work that y'all can do. Yes, sir.
Are the background checks and the fingerprinting, are they synonymous, or are those two separate?
They are linked together, but you would obviously do go in and get your fingerprinting done, and basically then that would be submitted to the TBI, who has their state database, which is linked into the federal database, and the chain of custody is fingerprints go from authorized person to take the fingerprints straight to them, and before they run and do the charge check, there's basically a list of someone that they hit the right part of the process.
Is that, with new applicants, that's going to be required?
Sure.
But existing appraisers, is that optional?
That's what I would have to really go back and look at the law closely. My experience with other federal laws is a lot of times they clarify things by rule later on. And if it is not explicitly said, there may come a day.
This is where,
There may come a day in the future where they say on renewal we want you to do background checks on everybody. But have they said that to date?
no, here's your language in page 53 in your book. On the bottom half, all candidates for real property appraiser credential must undergo a background screening. State appraisal regulatory agencies shall, at a minimum, obtain fingerprints of the individual in digital form if practicable, and any appropriate identifying information for submission to the Federal Bureau of Investigation and/or any governmental agency or entity authorized to receive such information in connection with a state and a national background check, not or, you have to do both. Here's the out. In addition to all applicants for new credentials, state regulatory appraiser agencies are strongly encouraged to perform background checks on existing credential holders as well. And that's one of the things. That's why I wanted to get the mindset of the
That's
commission.
really the decision y'all need to focus on. Do y'all want to go that far? Obviously, none of us have a crystal ball, but it sort of seems like they would like it. But it's our decision.
It's your decision.
Mr. Snyder?
Yes, sir.
Where would these places be located that the appraisers have to go to?
Currently, they're statewide. Because we have a long, skinny state. I know there are at a minimum 12 of these stations. More often, they're going to be in the larger towns and cities.
Well,
But I can get you a list, but off the top of my head, I know there are a minimum of a dozen, and I think there may be as many as 18 to 20, but I need to verify that.
but I'm just concerned about some of our appraisers in rural areas having to drive to Knoxville or Bristol or somewhere to, do this.
Well,
And
and keep in mind, we're doing this for securities agents, financial planners. I mean, somebody that lives in, I know two people in particular in Sparta, Tennessee, in White County, who I had sent directions to their nearest one, and I can't remember if it was in Cookville or Russell. So, I mean,
conveniently located.
and I'm 10 miles outside of a town of 1,500, so I'm always thinking that
Where's
way too.
Where's that?
Well, it's originally, I'm from Louisiana.
Okay.
But you know where Angola Prison is?
I've heard of that.
Yeah.
So
I lived
you
near
do.
there.
I will say this, the NMLS, we were able to go to our sheriff's department and have fingerprint and background check. So that may be an
That'd be a
option.
great idea. That'd be a
Because
great
they, did our whole county.
And there's just some chain of custody issues we need to make sure that when we receive those, if we're going to do those type of things, the sheriff needs to send them to the TBI, not hand them back to you, and then you walk them here, and then you say, oh, these are my fingerprints, but Nicole, and nobody saw you take your fingerprint.
And with a system in place, those will be fingerprint cards, they're not going to have those scanners in them.
Right, but they're...
They didn't have scanners. We had the cards.
Yeah, and the scanners are about 3 or 4 years old now, and they're starting to be more. They're starting to put them more in place because, as you can imagine, more often than not, somebody gets fingerprinted, they come back, they say this card's smudged, they can't read it, and people have to do it 2 or 3 times, and the digital gets a nice clear image. So just like everything else in technology, it's changing, improving, and becoming more prevalent.
I know in our community, they, at the UPS stores, they have the scanners in there. And that's where a lot of folks go.
So it's like all the insurance agents get fingerprinted. That's the thing now, yeah.
Right. So here's the rub, all right? Dodd-Frank requires reciprocity. There's just no getting around that. Dodd-Frank requires reciprocity with every jurisdiction. So we will have reciprocity with the Virgin Islands, period. As long as they meet minimum AQB guidelines and are in good standing with the subcommittee. So that's pretty much the minimum.
So when you say reciprocity, you mean if someone wants a Tennessee license and their license certified in another place, we will have reciprocity?
We will give them a credential if their license or certification is in good standing and they meet AQB minimums.
However, Florida does not recognize Tennessee. If you want to get a license to practice in Florida, temporary practice, you have to take their exams, their tests.
Not anymore.
This will fix
Not
that.
anymore. Not more.
As of
Because they've really been making people jump through
No,
hoops. there.
July.
July
this year.
13th.
July. As of July. They will be out of compliance if they fail to recognize this.
Good.
Great.
Correct?
Yeah.
Do you need to know today what this body thoughts
No,
are?
but I definitely want you all thinking about some of these issues. So let me finish the concept. All right. So reciprocity is required. That's not a negotiable tool. It's required. You can't do, according to Dodd-Frank, you can't do anything to a reciprocal applicant you don't do to your own people. The subcommittee has already opined you can't run a background check on an initial reciprocal applicant if you don't do it to your own appraisers on renewal.
Thank you, Mr. Snyder.
Thank you.
So, if you're not going to require background fingerprinting and background checks of everybody, we can't require it of out-of-state applicants. So somebody could be coming here from Michigan. We will not be doing fingerprinting and background check on them if they're certified in Michigan. They may never have gotten a fingerprint and background check, ever.
Question. If we require that anybody who wants to now obtain a license, i.e. certified general, certified residential, a license, if we say, okay, anybody applying for any type of license after this date has to have a background check and be fingerprint, would that not also apply to? Because we're saying that we're not treating the person now applying any different than we are people in their own state applying.
They do not consider them an initial applicant. They consider them an existing credential holder. They're an existing credential holder simply applying for a new credential. So if you don't require if you don't get a fingerprint and background check, you can't require one of Bob Jones from Florida,
Who's already licensed?
who's already licensed or certified and meets AQB requirements if Florida isn't doing it to them. Or if they are, or whatever. We can't look at it, we can't know it, I can't check them, nothing. It's just so I wanted you to know that there's that dichotomy. Either you're going to require it for everybody, or we can only do it to trainees and people changing from one credential level to another within the state.
So people who want a reciprocal license, even though they're quote new to us, are not considered new to the system.
And I vehemently oppose this idea because I went to Arrow and said, I think that they're new. They're new to me. I consider those initial applicants. The subcommittee and their attorney opined that those are not initial applicants. The same way they said you can't require them to take that Florida exam anymore. Those are not initial applicants. They're already appraisers. You cannot require an appraiser who's been an appraiser for 20 years in Iowa to come down and take the Florida exam, unless you require it of everybody.
So it becomes intrastate.
So I just wanted you to have that. It's a hard thing to wrap your mind around, and I don't care which way. I'm not invested. I'm an appraiser. If I have to go put my hands on the scanner, it's no skin off my nose. I don't care. I'm gonna have to do it anyway.
So you're looking at the initial $130 per appraisal to do, appraiser
I
to
get
do it.
nothing. Whoever does it will probably get paid directly, is how I'm thinking it'll come to be. But the law doesn't even exist, so I don't really know.
But I think each appraiser will have to pay for that to be done.
Right. You go.
And then at renewal, you're probably going to have another fee every 2 years or a year or whatever it is.
Right.
You
You do it.
These are not required at renewal. This is a one-shot thing.
We have to renew ours every year, the NMLS.
Background check's only good for the day.
Not fingerprints, just background checks.
Just the background check. Your fingerprints are good forever, probably.
You just go through a process on the
Unless you
computer
radically
and you're
burned
renewed,
them
so
or
I'm not
something.
sure what that entails.
Mr. Chairman,
Yes.
my thoughts on this, and I know she's trying to get a grasp on where everybody stands, since this is an open forum. I've been fingerprinted, so I'm not scared of it having fingerprinting. But the reality of it is, appraisers are burdened with taxes and fees here and there all the time. And it's just another undue burden and tax on appraisers in business, in my opinion, from a conservative standpoint. And so I would say that my opinion would be to do the bare minimum to meet these requirements and not put any more undue burden upon the appraisers for the profession. That's just my opinion.
Anybody else have any feelings, comments?
I've got to say, I kind of feel the opposite of that. I think appraiser integrity is the basis for our profession, and I think we should be willing to step up and improve undoubtedly. And I think if you're going to require it of new applicants, I mean, I've been an appraiser for 20 years. There's no telling what could be in my background since then. There could be some real moral problems that the board commission, the decision makes licenses, may have no idea about. And I think it's very clear what direction the wind is blowing as far as being compliant in the future, and I think it's just a prudent thing to do.
Question.
I think that I agree. I do
Go ahead.
agree with you on that, but I probably should have elaborated a little bit more. I agree with what the chairman's position on adding some language to the law when we make these suggestions to the legislature that basically say, similar to the TREC, it says within 30 days or 60 days of some type of violation, then you have to report that. That would help alleviate some of that concern.
Right, but if there's no background check, who's to know that they did comply with the law?
Another question, I'm willing to that.
Not everybody's as honest as we are.
Somebody, I have a gun carry, and I'm fingerprinted, I have a background check on it. And there are other appraisers, I'm sure, who have that same thing. Question, if they have to have it done once, would they, in that same year, would they have to have it done again for another agency for the state government? Since they're both state governments in it.
Right. That's one of the reasons why I kind of like the idea of piggybacking. The NMLS said, come on board. They're kind of like arms wide open. They came to Arrow, put on a presentation. They had 2 representatives. I'm so bad at names. I'm blank on the names right now, but it doesn't matter. The president of NMLS is Greg Gonzalez, who runs the Tennessee Department of Financial Institutions up the hill. And I was just lucky, and I went, oh my God. So I made an appointment with him, but unfortunately he couldn't see me until next week. That man is really hard to get an appointment with. I made an appointment with him end of October for the second week of December. So it's really hard to get an appointment with, but he's offered to help us in any way we need, and he's getting a whole bunch of his staff to meet with you at the same time. So, he had to make some, scheduling time, and they've offered to do it. And what happens is that if we want to do it you can run it as many times as you want to thereafter. It just costs, whatever to the applicant. It could be incorporated into the renewal fees. It could be whatever, but you just get your fingerprints done once, and then run the background check, sort of like you ping a credit report almost. It's almost like a credit report, except you're credit reporting your fingerprints.
I would like to see us sort of address the issue. If another agency within the state requires you also to have fingerprints and background checks, the appraisers not be required to have it twice, pay for the same thing twice.
And there's a lot of people who are real estate agents, there's a lot of people who are in the lending industry, and that's one of the reasons why I kind of liked it. Like, the NMLS required all mortgage brokers and licensee, lenders to go through this part of the SAFE Act, and I think that that's the direction as we're going, is that we're all going to be part of the financial.
Let's go one step further. Mention the real estate brokers and agents also going to have to do this. A lot of us also are licensed real estate agents and brokers. So that I have a gun permit, a licensed real estate agent, appraiser. I got there 3 times to have the same thing done, report to the same state agency, to each state agency. No, I'm just asking a question. I'm just pointing out that, I just don't think it's fair to anyone that the state or the federal government can impose a tax only, is what it boils down to. And then say, oh, by the way, no, if you go to another group over here in that same government agency, you got to pay another fee. That is just wrong.
I'm divided on the issue. It's certainly less work for me to go with just the applicants. Yet very few a year. And if you cut out the reciprocal, that's a very small number. We just had, 4 trainees applying for upgrade this month. We probably processed 10 new trainees and maybe a dozen trainee applications. So, I would have had to do 20 background checks in a month. That's not a big deal. If I had to do the 200 renewals I did at the same time, that's a much bigger deal, because we have a lot of renewals every month. So I'm divided on the issue. At the same time, the concept that somebody could come from another state and never have had a background check and come into Tennessee and gain it and do the same things in the next state and go state hopping without ever getting a background check, using the Dodd-Frank law as a loophole, is troubling. And there are certain states that are going to try to use there's a provision that says, in that Dodd-Frank, that says, unless your state meets or exceeds, and they're going to try and use it, I don't know, they're going to say their requirements exceed Tennessee's, which means they're going to try to say that Tennessee's requirements aren't the same as Wyoming has already said. We're not going to grant the other states reciprocity because our requirements exceed their requirements.
Well, I can guarantee you probably Florida's going to have that.
They may do that as well, and I can almost guarantee you they're going to be in danger of derecognition. If anything, the Dodd-Frank law will come down on them pretty hard. So in my opinion, and this is my opinion, and I don't even vote, so it doesn't really matter what my opinion is. I'm just telling you what it is. I think that the legislators spoke very loudly when they passed this law saying, you will have reciprocity. You will have it. So that, to me, that was a very loud and clear message. You will have reciprocity, period. Or you will be in danger. You will not do federal loans. So I don't care which direction it goes. I'm not personally invested. My background is clear. I know that. So I'll put my hands on the scanner if I have to.
So are you expecting us today to give you a recommendation as to what we think the way it ought to go? Or are you asking us to please consider this and maybe report back at the next January or February meeting?
You can articulate your viewpoints now if you wish to. You can defer, but remember, the subcommittee is going to be in the room next time. So, whatever you do, think about it before you just say it in front of the subcommittee.
Sure.
Yes.
I don't know exactly where I stand on this right now. I'm not sure you got this thing, but I have to tell you, getting registered in 27 states now. AMC. I understand where you're coming from. It's just one more expense. It's just more money. You know, it's another hassle. But I guess I can say, you know, it's the cost of doing business. I don't have a choice. You know, and if I want to operate in that state, I got to supply my fingerprints. You know,
I agree with you, Jason. It's the cost of doing business. I reckon one of the problems I have, I just do not like the idea of this great big brother federal government states saying, we're going to make you do the same thing 50 times. You're going to write your name 50 times to make sure you know how to spell it. I know how to spell my name. I mean, you do it one time, you know how to spell it. And I just disagree with the principle that I'm going to have fingerprints and background check done for every organization I belong to that requires this in the state of Tennessee. We got computers. In fact, the gentleman who's here said we don't even have to, all you got to do is lay your hand down. It's all digital. If we can do all this computer stuff, why do I have to do it pay separately for each individual license I might hold when they've already got it in their system? I mean, I can understand having to go back every year because, like Cole, I think very aptly put it, it's only a snapshot. That's why we have dates of appraisal. It's a snapshot. What's going on as of that date. By having it once every year, then you are able to keep some track of what's going on during that year to make sure we kept our nose clean. But by the same token, once I do it and it goes into the state system, then the state ought to be able to pull up that. But any other ordinance, any other board, any other license that I might want to hold here in the state of Tennessee, I shouldn't have to go back and take my time and spend the money to keep reinventing the wheel. That's my concern.
I completely agree with you on every bit of that, but I don't think we have the power to control that.
Well, I think we
can
need to somehow or another let the powers to be know that we agree with them as far as the background, as far as the fingerprinting, but if we're going to do it, and it's going to go into a state database, which I assume that's where it's going to go, is it not, Nicole? Why do we have to do it for every other license that we're required to have by that same governing body, i.e. state of Tennessee, i.e. federal government?
That's not a question I can ever answer, because you're asking me about a lot of different things. Here are the things that I need you to think about, all right? Fingerprint background check. It needs to be both state and federal background check. It can't be just state background check. It can't be just TBI. We need to consider whether it is going to be everybody on renewal and on initial, or just initial. Okay, those are the two concepts: state and federal, and initial. The law, however it comes to play, has to be reviewed by the FBI for approval before they will grant access to their national database. That will take time. The governor's office has already indicated to our chief counsel that they are not going to carry this legislation, this package. So it has to come from some other source other than the governor's office. Someone else has to carry this legislation. I have some language that's been drafted up. I don't care who runs it. I don't, you guys can do what you can. Retro, you can have some other professional organization help with it. I think we should start inviting the professional organizations to our meetings. If they come, great. If they don't, but I definitely think we should give them a slot on the agenda so that we get some more participation from them. There's a political, the Tennessee coalition. I think they should start sending someone to our meetings as often as they possibly can. I think
online poll. Those are cheap and easy.
yeah.
I think that would be very powerful. Because my personal fear is when I go to seminars and meetings and chapter meetings and things like this, those of us in this room are going to take the fallout of this, in addition to you guys, frontline staff. So
It's going to have to go through. It's going to have to go through some state representative.
I thought that this had to be done this year.
It does. really does.
I thought we needed to have it ready in January. We needed to have our representative picked out, and we needed to be ready to lobby and get this thing passed by June.
If we don't get it done, the implementation is the part that I'm concerned about. It has to pass. We have to have this approval. It's a federal
This year,
requirement.
this coming.
The implementation has to be ready by 2015. How, since we've never done it before, how are we going to do it? If they set it for a June of 2014, if that's when they intend to have this implemented, how am I going to get this done in 6 months?
Mr. Evers, did you indicate the governor's office is not supporting this legislation?
It's not that they're not supporting it, they're just not going to carry it.
But they'll have to have a legislator submit it, but are they going to support it once it's being presented?
I don't think you oppose it. I can't imagine
I mean,
why they would.
I misunderstood. I thought you were, so they're not for the implementation of this Dodd-Frank component.
Or they just say they're not getting involved.
They just don't want it.
He's just not going to sign it into legislation. It's going to have to go through the House.
The governor submits a package every year where they draft up language and submit it for consideration to the legislature. He's just not going to include that as part of his package. It's not that he's opposed to it or for it. It's sort of neutral.
There's just a lot of things that get submitted to general legislation package, and that just gets.
So from this body standpoint, then that package it will be submitted by someone in the House and the Senate.
But not necessarily.
I can't hint any stronger. This is me as strongly as possibly hinting to you all that use whatever political power you have with your people that this needs to get done. Because how are we going to get the word out to the licensees? Most of the licensees aren't even aware of the 2015 criteria.
So what we need to do then, who goes about actually drafting the legislation to be considered?
Anyone can.
I
I
know
have
that,
some
but I mean,
language.
Do you have it ready? Good.
Right, if you've got it ready,
We can run with
What
it.
goes into that language.
you've already got it ready for us to consider, right? The law is already written for us to consider, right? And then, okay. Would it be possible then for us to have a copy of that so we can have someone approach a legislature about carrying it?
Yes. And that's
I'm probably the most non-political person in this committee. So, but I'm hoping we got some people here who know some legislators. I'm hoping that Mr. Mark Johnson will step forward, and maybe Mr. Mike Green and Ms. Nancy Point will step forward to help us corral someone.
And that very neatly ties to the next portion that I have on the thing, and these will go very quickly. The other ports, I'm sorry, I didn't mean to cut you off.
If we don't have our heads together and know
Yeah.
what we're
Exactly.
going to support and submit ourselves,
That's the reason why I want
we
to know.
can't take it to a legislator and say, well, here it is, and then we start waffling on what's going to be in it.
That's why they would go back to Mr. Green.
Okay.
Which one was that?
Getting some other ideas besides our own in this room, you know.
Well, the problem is, I agree with Mike, that we need to get some other input, but the bottom line is, folks, the way I understand it, the federal government has tied our hands. We don't have any options. We've got to pass this legislation, or otherwise they'll decertify us, period. The only thing we can do, if we send out, like Mike suggested, which I think is a very good idea to get feedback from the people, but if that people come back and say, that's the worst dumb idea I've ever heard in my life, I'd be against it. We got 90% of them out there saying, I'm against it. We still got Frank Dodd over here saying, you're going to do it or we're going to decertify you. So we still
There's two
kind of...
levels there, though. I mean, Dodd-Frank says you must do new folks. It doesn't say you have, it strongly encouraged you to do existing folks. It doesn't say you have to. And it's the existing folks that we're going to take heat from.
Dodd-Frank doesn't say anything at all. Dodd-Frank says you will comply with the AQB requirements, and the AQB is the one who proposed this. They did this proposal in 2010, and no one opposed these requirements.
Mr. Chairman,
Yes,
question for Ms. Havers. The AQB, the subcommittee will be in next month,
Yes.
and then legislature will be back in session by the time we meet back in February, if this is not taken up in January, they'll be well into their agenda. So I'd like to make a motion. I'd move that we adopt the real property appraiser qualifications criteria, minimal guidelines on background checks under section 6 on the criteria applicable to all real property appraisal classifications.
The page there, Mark.
That's page 53.
53, item 6. So you're saying,
I would adopt what they have classified as their minimum criteria, which basically would be on new candidates and not existing.
I think that's an excellent recommendation.
Okay, do we have a second to that?
I'll say,
Got a second, Mr. Green, discussion.
I'm okay with that, but I think we are going to wind up addressing this again sometime in the future.
What this the text says, this will only apply, quote, to new people coming in,
Just
right?
the initial training.
And then we'll also, then those who apply for reciprocal, will not address them at all.
Will not address a single reciprocal applicant. And there are other things that we're going to briefly touch on for reciprocal too.
Let me ask you a question. We're saying that we're not going to require that of reciprocals, right? When they come in. Well, if those states have got to abide by the same law, wouldn't they have already gone through that also?
You just said you're not going to do it to your people though.
No, I didn't say that. My question was, if I make an application for a license, I live in Michigan, okay? And every state is required at a minimum to, have this background check on people coming in after a certain date, correct? Then the possibility is that that person who's applying to us here would have already gone through the background check.
Only if that state required it.
I understand.
Only if that state required it and they applied after that date. So if they held a credential for 20 plus
Sure.
years, like many of you, no, probably they didn't have a background check.
Correct. But once again, what
but
I'm
it'll
saying
vary.
is we're narrowing it down a little bit more.
Right.
As far as that's
It'll
concerned.
only be the initials. So most likely, I would say 95% of the out-of-state applicants will never have received a background check. Just guessing, because there's only a couple states currently that have background checks.
Mhm.
so what percentage, we're dealing with an underlying problem, undoubtedly. Well, how pervasive is that underlying problem? Is this a federal knee-jerk reaction to not a huge problem? I mean, and what makes me think that, you're talking about a whole group of seasoned practitioners with 20 plus years. What about the marketplace, correct? The marketplace dealing with these people. Doesn't the marketplace do that?
I don't know, these are the questions that should be addressed to the ATV, and you get your opportunity for sure in 2015, but I'm going to try and make sure that you get your opportunity before then. You can always attend their meetings on your own, of course, their meetings are public, but and they always issue exposure papers on anything they propose to change, which they get very little comment on, much like the use path exposure letters that go out. But
Chair recognizes Mr. Point.
The Tennessee Appraiser Coalition has a PAC group that has been in effect, and we have raised money to hopefully set up a way to help enhance this process if the legislation were ready. If we have something ready to take to a legislator to start through.
I would just do what Mr. Johnson said. The only addition I would say is put in a date beginning on January 1st, 2015, beginning on July 1st, 2014, to allow some time for us to, learn how to do it before the law really goes into, the federal requirements.
I would amend that motion, if that's acceptable to the chair.
Yes.
And so I move that we adopt the real property appraiser qualifications criteria, minimum guidelines on background checks under section 6 on criteria applicable to all real property appraisal classifications to go into effect no later than January 1st, 2015. That's when this
Right.
says it's effective.
Yeah, we have to have it in effect no later than that date.
That gives you the whole time frame.
Right, I can't, if it's in the law, I can't do it sooner than that date to anyone. So it would have to be, on or before this date.
Give us some time to work through the process.
Right, so,
And on or before January 1st, 2015.
anyone applying January 1st, 2015 or after would be subject to background checks and fingerprints. That's not, that's not a lot of time to,
2015, well, then that would just be,
that would be
that's
on
when
the
it's
effective
due
date.
anyway. We're just
Right,
being in compliance with what we're being forced to do at a minimum.
right.
You want to back that up?
If you want to back that up.
Give us 6 months to practice, get it in.
The
Get
subcommittee,
it up and running, get it up.
It's effective,
it is going to be a big deal, and I've been
effective
panicking.
June 1st,
I've been worried about it
2014.
for a year now.
I've been panicking because I think that the licensees are not going to realize what's going to happen to them.
No.
But let me rephrase it, and we'll go effective July 1st, 2015, 2014. Therefore, 2014, therefore, if it gets stalled in the legislature this year and it gets picked back up next year, they'll be included in their session and hopefully will pass some type of action on it by that point.
That sounds very reasonable to me.
All right. We
Okay?
have a motion, do I have a second?
I'll reset.
Second by Mr. Green. Motion was made by Mr. Johnson.
Yep, we got it.
Okay, ready? Okay, any further discussion? All in favor, say aye.
Aye.
Opposed, like sign. Now, when,
Very quick,
I'm
I'm
sorry.
sorry. Would the PAC be willing to work with the Institute and the other organizations to get the poll online so that we can get this feedback?
I'm sure.
They can't really oppose the federal minimum, so that's what we,
No, I'm talking about for existing.
You're saying do a poll on it.
On the existing, not on what the motion was, but on background check, the existing license.
Yes. I'm still concerned about us requiring these background checks and fingerprints when the applicant has already complied with this requirement of other, like Rosedale, if she's already done it, why should she be required to do that again when the state has already got her background as of a date?
And it's federal.
As of a date.
I think a way to handle that is when we get whoever is going to carry the water on this bill, to get them to include that in there.
this is a minimum
Yeah.
requirement. Unfortunately, this is not negotiable. We have to do this by January 1st to every appraiser in the country. It's not negotiable.
I agree, I am not opposing that.
If we can't take something on the bill that will hold it up.
Right.
I don't want to hold the bill up either, but at the same token, I just don't want to keep putting on additional costs on the people of Tennessee by a law that the federal government says we've got to do. That
And it's redundant.
Yes.
The
I mean-
appropriate way to fix that is to express your concerns in writing to the Appraisal Qualification Board and get the requirements changed. But we, as the board, have to enforce the minimum requirements of the AQB pursuant to Title 11 of PIREA. We have to at least make the minimum AQB requirements. So you're not requiring anything that isn't required in every state. I think it's a very well reasoned recommendation to propose to the legislators just to meet the minimum requirements. We have the statutory authority to make that recommendation to the legislators. I think it's a good thing to do. Unfortunately, appraisers are going to have additional requirements, and many professionals across the country other than appraisers have additional requirements. It's a
not that
changing world.
I realize that, and I'm not, we're required to do this, we're required to do it. That's something to me. By the same token, I don't think we should be required to keep reinventing the wheel. And I feel like by requiring an individual to have 2, 3, and 4 background checks, and all the data going into the state or federal agency, to me is redundant.
I know, but the commission, as a whole, in my opinion, should present a united front to the minimum criteria. The trainees and the licensees are going to already be frustrated and confused by this process. Best we can do is show them that we know what we have to do, that we're going to do the same thing to everyone. And, it's just, these are the minimum requirements for all appraisers nationwide, and we're just going to enforce the bare minimum for everyone. It's reasonable, it's fair. We can't dissent something that the AQB has done outside the appropriate forum. It's not for the commission to oppose. If you want to oppose it, you should do it at the AQB meeting as an individual, or even as a whole board. Write an opinion letter to them saying we should change this requirement.
I don't think so much that you oppose the requirement, just the implementation of it to be able to smoother and prosper.
Exactly. I'm not opposing different, the requirement to have it done. What I'm opposed to is them asking me to do the same thing 3 or 4 different times.
Why don't we do this?
That's calling
with the minimum that Mark suggested, and start pursuing those requirements in typical legislation, and then in a separate effort, we could contact and talk to legislatures to see what we do to unify the fingerprinting system.
Did we have voted?
And say, I think there's kind of 2 separate issues.
Approve this? Okay, so we've already approved it. So now we just got an implementation, correct? That'll have to be.
I'll give the language to whoever the subcommittee is appointed on. That's the next part. I just broke down in the next section of the director's report the things that are going to need to be changed, just very practical based. There needs to be, this is all part of the AQB requirements broken down in the book. There needs to be a trainee supervisor course. A couple of courses exist already, but the AQB doesn't specify how many hours and what should be the specific content. They did release a content paper on what they consider recommended what should be in the courses. January 1st, 2015, there has to be a course required for all trainees and all supervisors. So if you're going to be a supervisor or you're going to be a trainee, you're going to have to take the course, period. Or you're not a trainee anymore. Or you're not a supervisor anymore.
Is that in this right here?
I can't see what
This
you're...
is the appraisal foundation, appraisal standards board.
Nope.
Exposure draft. This is something
That's for
different.
USPAP. That's
Okay.
different.
I'm sorry.
But the criteria trainee supervisor course will be in here. And there is an exposure on what they think the letter should be or what should be in the course content, but it's still a state decision. I would recommend you require it be a 7-hour course. There's already 2 trainee supervisor courses that are 7 hours in length, so at least the course already exists as a bare minimum.
It's not called a trainee course, is it?
Supervising trainees is how one of the courses are called, and then some other version of the exact same thing. It's another course. But yes, it's called supervising trainees, and trainees and supervisors are encouraged to take that course, but it's not a required course. I would, like I said, I would encourage the commission to set the rule at a minimum of 7 hours. One of the things to consider is whether or not there should be a Tennessee component to that course, whether or not they should be a certain number of hours on the Tennessee laws and rules. Just something to consider. We will have to establish what the minimum content requirements are. Probably the easiest and best solution is whatever ultimately comes out of the AQB's exposure draft, adopt that. Probably the very easiest solution. problem.
No, they've already made this a requirement.
I've already made it required as part of the AQB 2015 criteria changes.
They're not just now exposing it for comment?
No, the criteria existed, that there will be a trainee supervisor course, but they didn't say how long it should be or what should be in it. So you could potentially make it a 2-hour course. Or a 10-hour course. Does it have a test? Does it not have a test? Does it specifically address your state law? Does it not? What is it, you know? So when Dr. Barilla or whoever subsequently follows Dr. Barilla reviews the course for approval, what are they going to be checking off to see if that course meets its minimum requirements?
Well, I would hope that we get the supervisory appraisers would get continuing ed for 10
Yes,
at least.
they would get, that's why I think 7 hours is reasonable. If you set that as a bare minimum, 7 hours, it would go towards their CE, and then they'd have to do that only once every certain number.
Who has developed these courses so far?
Appraisal Institute has one, Hondros has the content, Trees offers it. I think there's another school that offers it too, but I'm not
Do
positive.
they
off the
offer
top of my head.
both the supervisor and the trainee?
It's a supervisor/trainee course. It's
So it's one of the same?
Yes.
It's just not two separate courses?
They go together.
yes.
What if you have more than one trainee?
So you only have three.
You just have to have it, like, I'm gonna have to create like a little checkbox that said, yes, they completed this course. So, I think you only have to take it once, so I don't know how often, but that's, my recommendation is that the easiest solution is probably whatever washes out of that, we'll just have to adopt that. All we have to do for that is a rule change. I mean, that's a big hurdle, but nonetheless, it's less of a hurdle than a law change.
A question. So consequently, for somebody, how are we going to control the supervisor as far as taking this course, or the trainee as far as taking this course? Do we have to submit something to the state to say that we now have a trainee? And since I've now hired a trainee, I got to go take a supervisory course. I got to take the trainee with me to attend this course. Or if I get another trainee, then I got to go back and both of us take that same course again.
Again, this goes back to implementation. This is one of the reasons why we cannot wait for law and rule changes until 2015. We're going to change the rules, notify the trainees and supervisors that currently exist, set up a mechanism for the new applicants to notify them that they will not be approved until you complete this. And those who do not meet the requirements by 2015, you will no longer be a supervisor. Those who no longer do not complete the course will no longer be a trainee after that date.
And we will be able to provide them with a list of people who will provide these courses or can provide these courses.
Well, there's already an approved course list on our website. There's 2 courses that, in my opinion, would already meet this requirement. Bare minimum, they're 7-hour courses. But I don't think that it's going to be a problem if that's the criteria. If you want to make it a higher requirement, like saying there's going to be 2 hours required of Tennessee law, then you're going to have to allow time for the course providers to develop the course, write the content, develop the slideshows, practice, and get it out there.
So that's my concern.
And that takes 6 months to a year for a provider to do.
Well, that's my concern. Who are the instructors right now that are approved to put on these courses?
Yes. Appraisal Institute and Trees are already offering trainee supervisor courses.
They're the courses. Is there also list who the instructors are for these courses?
Couldn't this be implemented like you do USPAT every 2 years, USPAT compliance, sort of a similar mechanism as that? So that implementation would be that tough.
Right, but unfortunately, it's a drop dead date on January 1st, 2015. So all the trainees, the 243 that it was on the previous page of the director's report, if you're not already upgraded,
And so any
course.
appraiser out here right now to either has a trainee or might be thinking about getting a trainee has to also take that course, correct?
Correct, sir.
Which means that we're going to really potentially have a great influx of people wanting to take that course. For one
Yes.
reason or the other.
Yes.
So we need a rule change ASAP.
Well, and you had a rule making hearing in January of 2012.
Right.
The rules are still sitting in the Attorney General's office. They've not been passed and implemented yet.
Just because we make a rule change doesn't mean that it gets stamped as it's your fault.
Yay, buddy.
Well, they have been in there for quite some time.
Since at least March.
So,
So you need
so
a motion
consequently,
from
if
us?
we make a rule change in, there's nothing that says it's going to get implemented.
That's why we're going to need some lead time. I know we can do emergency rules, which technically means that you can implement in 90 days. I think 90 days for emergency rules, but let's not come to emergency rules if we don't have to come to emergency
Well,
rules.
yeah, well, that's the thing, that's another problem I got. And if we get down to the last minute and put in an emergency rule for 90 days, then we still haven't been able to get our supervisors and trainees into the course yet because it just got approved. And so here we are right back to square one again. We got supervisors and trainees who are in violation of the law because we did not pass the law in time to get it implemented.
Well, it's not them violating the law. We do Tennessee outside of the requirements. Anyhow, that's why I'm bringing everything to you 2 years ahead of it. You're going to get ahead of this, and it will not be that hard for us to draft rules to be in compliance with the minimum requirements. But I am here today, this is why the director's report was so long, and this is why I begged you all to watch that video.
I did.
Watch that video, is because I cannot do this without you. This is too big for me. The licensees is my biggest concern, is that they are not hearing that the requirements are changing. The experience requirement minimum, so for someone starting off today, is 24 months of experience. We are 24 months from implementation. So if you applied for registration this month, you can't upgrade prior to the requirements, which means if you want to become certified, you will have to have a college degree, period. You will be fingerprinted and background checked. You will take the national exam, that's required. You will have the experience requirements. You'll have to finish your experience before you take the test. You can't do the education and then take the test anymore starting January 1st, 2015. That's on there. You will have to take a trainee supervisor course or you're not a trainee anymore.
Can we send out a certified letter, return receipt, to each of our 200 and plus?
I have been sending every new trainee a letter with these requirements, the summary, but I sent these all to you a year ago. Did you know that y'all had to take a trainee supervisor course? Did y'all know? I mean, I gave it to a lot of people, and I've already distributed it. It's been on the website for at least a year. It's just, I don't think people are hearing it. So what I want to do is do as much outreach in the next 24 months as I possibly can. That means I'm planning on at least 6 times a year doing public speaking engagement with one of the professional organizations, one of the political groups on the Tennessee Appraiser Coalition, doing, just going to their meetings and doing a 30-minute blurb on the 2000 criteria. So I don't even know what to say right now. At this point, I don't know what to say. Are you going to have to get fingerprinted? I don't know. I'm going to have to say that to 2,000 people. I don't know.
Was there just, Ms. Edwards, those 2 courses that are there, I hear you say earlier, would there be a separate portion of that would be specific to Tennessee rules?
It's just something you all need to consider if you want that to be a requirement.
If that was a requirement, are these courses that Trees and the Institute are offering now, are they being specific to states or are they just general?
They're just general courses, so they would need additional time to change those courses. So they would probably take that 7-hour course and change it to a 9 or something. I don't know.
Just my thoughts are that would be to be able to utilize what's already been prepared and kind of accepted norm across the country. To try to add 2 hours of Tennessee rule to that might become very difficult for some of these other institutions that offer a course, you know, in Biloxi one weekend and then Little Rock one weekend, because they just trying to think logistically whether it may sound good, but can you physically get them to buy into that? I
Right.
don't know.
And it goes to the reciprocity issues. We have supervisors that don't live in Tennessee.
Well, in the also, what's the benefit of that? Why don't we standardize those type things, make it simple, and just get in compliance? I thought that's the duty of this commission, is to make things operate smoothly when we have the opportunity to do.
I certainly think that would be the easiest route to go. I don't know. It might, it could be an ounce of prevention. There's certainly a benefit to having somebody sit for a certain number of times here, that there is a requirement that you do this, that, and the other in Tennessee, just so you know. Certainly, I am more than slightly tired of having to repeat you can't send your trainee out to inspect properties more than 50 miles from your office. Oh, you can't do that. It's the rule. You've never read the rule. You know, like supervisors are unaware of a rule where they signed an affidavit saying, I promise I won't send my trainee more than 50 miles from my office without my supervision. Okay. But there's a benefit to it. I can see a benefit to a Tennessee component, but at the same time, how hard is that going to be? So it's a commission decision. I will, whatever the will of the commission is.
Mr. Johnston?
Would you like a motion?
Yes.
I move that under the proposed rule change, the trainee supervisor course be at least 7 hours in the course, and the content requirement meet those described in the AQB guide note or interpretation to become effective July 1st, 2014.
Second.
A motion, second, discussion.
So we need to have a rulemaking hearing
Yeah.
as to what's.
This just gives me your intent. You can always change your mind when you have the
I'm
rule.
just trying to get some lead time, like we've been dealing with this lead time issue.
Okay.
And they both
Well,
need to be corrected.
Mutual design, all for the most part.
Okay, and I'm going to go as fast as I can through the rest of this.
We got a
I
second.
don't have to go.
One second.
Oh.
Are we going to ask Dr. Varela to review the courses that are now available to see whether or not they meet his criteria, our criteria?
It's a kind of a cart before the horse thing. First of all, Dr. Brilla's term is going to end in 6 months. Second of all, we don't have the rules done, so you can't evaluate the courses that exist to a criteria that doesn't exist. So we're going to have to wait till the rulemaking is done before we can develop the checklist to be done.
Okay, thank you.
The experience component is not significantly changed.
Well, we need to vote on it.
Yeah.
Oh, I'm sorry, I thought that was done.
I'm sorry. All in favor of Mr. Johnstone's motion, say aye.
Aye.
Opposed, like sign.
The experience component of the AQB did not significantly change. The one thing relating to experience that changed is that you would have to complete your experience before you pass before you're allowed to take the examination. The AQB is developing and will probably in the future allow professional track and practicum courses. For the practicum courses is currently allowed, but there really aren't nationwide very many practicum courses that exist. They are trying to develop practicum courses to give to the colleges and universities to offer. There, for example, is a course in New York City where students can appraise a skyscraper, and they like break it up, 5 students on one skyscraper, and at the end of the class, if you pass, you get 500 hours of experience. So, it's a practicum course. It's real world, but not real world at the same time. You have a teacher teaching you instead of a supervisor giving you credit for experience. College requirements are the biggest change that I think will make many of the trainees freak out. The license requirement, there will be an in lieu of option still. There will be 30 semester hours of specific college courses or an associate's degree required in 2015 or sooner. But certified residential and certified general will have a bachelor's degree requirement. The in lieu of option is going away. It is very important that everyone understand there is no grandfathering. If you are a registered trainee, that doesn't mean anything. If January 1st, 2015 rolls around, if you haven't actually obtained the credential, you are on the new requirements entirely. Education, experience, examination. So there's going to be a whole bunch of people that said, I got my 120 hours before 2008, so I'm good, right? You are not good. If you're not certified before 2015, you are not good. You're going to have a college degree. So that is probably going to be the biggest freak out when the licensees start hearing it. I've been trying to get them to hear it, but I don't think they're hearing it, and I think there will be a lot of people that are maybe shocked. Well,
It's going to be a dying profession because those old guys will say, with this.
we already discussed Dodd-Frank requirements and reciprocity, so I'm not going to re-recover that. I'm just going to say that the ASC is starting to review states beginning in July of next year for compliance with Dodd-Frank. So it's going to mean a lot of things. We actually were lucky. The Dodd-Frank requirements had an implementation of July 1st, 2013 for most of the requirements. There were a lot of states that had requirements that were not in conformance, and Tennessee generally already had most of the requirements. Like Mississippi had a credential that didn't meet licensure requirements of AQB. They had a license that was no experience required. That has to go away by this July. Go away. That you cannot have a license and not have it be AQB. We already had trainee and supervisors that meet minimum AQB requirements. There are a lot of states that don't even have trainees. That has to be implemented by July. So we actually were ahead of the curve on a lot of the stuff, and we're in compliance on that stuff. So I just wanted to say, like, kudos, we were ahead of some of that stuff. For trainees, supervisors, licensure, and reciprocity. We actually have more reciprocal agreements than any other jurisdiction that participates in ARROW, as far as I know. So we have 35 reciprocity agreements, and we recognize all the other states too. It's just that on renewal, you have to do Tennessee's renewal requirements if we don't have a reciprocal agreement. So that's very reasonable. It's the opinion of the director that Tennessee currently meets or exceeds all of these provisions, which are anticipated to be reviewed by the ASC after July 1st, 2013. However, the changes for 2015, which includes the continuing education, fingerprint and background check, training supervisor course, are considerations which need to be addressed in reciprocity rulemaking planning. Reciprocity policy does not currently incorporate trainee level applicants. We don't grant reciprocity to trainees. We make them meet Tennessee's requirements for the Principles Procedures Use Path. Many states allow 100% online qualifying education, which currently does not meet Tennessee's requirements. Current laws, rules, and policies applicable to reciprocity do not address renewal requirements at all for out-of-state licensees, and do not contain specific language regarding the period of time a person may not reapply after expiration. In my opinion, and I don't know that this has been greatly abused, but in my opinion this creates a loophole. An out-of-state person can apply through reciprocity, be granted a credential, not meet the continuing education requirements, let their credential expire, and reapply. We don't have a provision in the law or rule that says they can't reapply. Many states do not audit continuing education 100%. They just do like 10% of their entire pool. Many states do not require 14 hours in classroom. So you can just keep reapplying and not do the continuing education. That is my opinion. May not be interpreted by everyone that way, but my opinion is that rest, and I'm the one who pushes approve on the renewal, so my opinion does have some weight. My opinion is that it creates a loophole for people to not comply with the continuing education requirements.
How would you fix it?
Either have a statutory provision on how soon you can reapply and how long the grace period is for renewal. And that would require a law change. We have, in the rules, we have a requirement that you can only renew a license for 6 months after expiration, and after that you have to reapply. Reapply means trainee. So if you're a certified general, let your credential expire for 6 months, you're a trainee again if you were to reapply. But if you're an out-of-state credential holder, let's say you hold a credential in Illinois, you decide not to renew your Tennessee license and you didn't do your continuing education, you reapply in Tennessee, we don't audit your continuing education on application. We just check to see if your credential is good in Illinois. Just something to think about. Like, it is one of those little loopholes in the law. Continuing education.
Do most states still require a letter of good standing?
Not for renewal.
No, not for.
That is being strongly frowned upon by the ASC because that's what the National Registry is for. We will accept either a letter of good standing or we'll check the National Registry. We kept the letter of good standing language in the policy because if you're a brand new applicant, you may not be on the National Registry. So are we going to hold you up for 45 days while you get on the National Registry? Just seems mean.
I was just wondering about people getting reciprocal and being able to go to another state, do appraisers.
Right.
You know, if they have to get a letter of good standing, then would that solve the problem?
No. Many states only audit 10% of their licensees for continuing education.
Well, at this point, though, we have bigger fish to fry.
But if we're going to fix the laws and rules,
Let's fix them all.
I'm just saying. So I'm pointing these out.
This is a law, not a rule, correct? We would have to get something through legislation.
I'm not really sure. The continuing education, you might just have to be able to be more clear in the renewal policy. So something that I would encourage the commission to look at. Very important law. Mr. Johnstone will probably very much enjoy this law and maybe had something. No state law regulating real estate appraisers shall be more stringent than any federal law regulating real estate appraisers. Is in your current statute. So any federal law regulating real estate appraisers. One thing that I think we might actually be in excess of is our continuing education requirements because we don't allow online education, but the AQB does allow online education for qualifying continuing education. I'm not sure if that would be interpreted as more stringent than the federal law. So it's something to consider. We may have to reconsider the online education. We've actually had a lot of people complain about it since the last rulemaking hearing. So duly noted.
Nicole, along that line, one of the people who violently disagreed with that position went ahead and did go take all the courses. Had a state in person so he could get his license. So it still works.
And in the keister, isn't it? The bottom of the next page, the AMC, I would strongly encourage, while we're doing law fixes, to fix the biannual to biennial. I think it was a legislative intent for it to be a 2-year requirement for this to be audited, not a 6-month requirement. But I am doing a 6-month requirement. And I think that the AMCs will admit, the AMC member in the room will admit that it's annoying. I don't charge for it though, so I'm just sending out a form for them to notarize and send back. But we've already processed 4 complaints based on that. So failing to turn it in.
As we were talking about in the legal report, this is where I think maybe we ought to bring this up. During that recertification, we ought to get some notice of service sort of things. Who are your principals? What are their social security numbers? What are their home addresses? So that when we have these fraudulent actions and these refusals to pay, maybe we can find them at least.
Biannual,
Database of who's involved, if they come back up in the line.
Whatever we can do.
the biannual notice does have the name and address of the AMC and the name and address of the controlling person. I can do it for all the owners.
I think if you want to operate as an AMC in Tennessee, you need to submit all this information.
The application, not the biannual certification.
Well, let's amend that biannual. Let's empower ourselves to protect our appraisers.
Okay. Duly noted.
All due respect.
You guys are the ones who passed the laws and rules, so I'm putting it in the minutes.
Mark's getting a motion.
We don't need a motion, it's good. It's good.
Do we know it?
Use PEP discussion, Mr. Hall wanted to discuss what was in the record-keeping requirements. Tennessee law, I put it in there. Essentially, it mirrors use PEP, name and identity of the client, true copies of any written reports, document on any type of media, yada yada yada. And I put in the FAQ from the standard board on work files, what should be in and that kind of stuff. Want to talk about it?
Let me make a quick comment. What brought this about was we were reviewing some complaints that had been filed, and there was some allegations made along the way that the work file did not include all the data. And I said, okay, what is the work file? In that office, we have various national publications there that tell us about what's going on as far as the various markets are concerned, i.e. apartment, industrial, office, etc. We've got one that also tells us about the difference in the cap rates, what they are, national, local, what grade they are. We also have every appraisal journal dating back to 1963. Now, the question I have is, if I refer to any of this data, do I have to make a copy of it and actually physically insert it in that quote work file? Or can I just say, I have this information in my office, if you will see it, come by, there it is. What's the work file? And I'm just concerned that once again, I don't see any need of wasting paper, wasting time, making copies of all this stuff. You put in the quote work file, if you've got it there in your office, just to show you what a cheapskate I am. If you'll notice, all this paper like I've been looking at today, it's all recycled paper. I've already used it once. I get on the back side of it, use it twice, so when I get through it, I've got my money's worth. But I am just concerned that the work file is being interpreted to mean you gotta have in there everything you ever thought about, ever seen, every note's gotta go in there. And I'm thinking maybe they've got a misunderstanding with some of our review appraisers that they're saying or doing. But I think, once again, we need to have some common sense about this stuff. You got rules, you got regulations, I'm all for following those. But let's do not lose sight of what is practical. You know, if I'm making up data, yeah, nail pretty good. But when I got that information in the office there, and I don't know about you guys, but I've been doing this for over 50 years. A lot of it I don't have written down. A lot of it's up here. A lot of my reports that I write are based on what's up here. I do not try to put in my work file every thought that I might have that comes down the pike. When I'm doing appraisals, for instance, for TVA, or for Piedmont Gas, and that gas line is coming under a TVA easement. So then I go to appraise a TVA easement, and we get down to the after value. Well, I don't always go back and say, well, you know, back in 2010, I did an appraisal, and this was what happened. Got my files there where I appraised it. I know what happened. So I'm just saying, let's don't get so tunnel vision as what needs to go in a, quote, work file. Make sure that people got the information, that know where they got it, and can relate to it. So that is just my observation. I just wanted to get that out to maybe convey to our review appraisers that I think we've got to abide by the law, we've got to abide by the rules. I am not suggesting for 1 second that we do not do that.
I haven't seen any citations for not doing any of that. The Standards Board opined on it that electronic copies of documentation is fine, and they also, to answer your question, references in the work file to the location of documents is used to support an appraiser's analysis, opinions, and conclusions can be adequate. It's not always necessary for an appraisal work file to include all documentation, provided the reference material is retrievable by the appraiser throughout the work file retention period. Care should be exercised in the selection and format of the location documentation. So you wouldn't want to choose something that someone else has control of, like the MLS that could be altered, changed, deleted. You can always save an electronic copy of an MLS sheet or something like that, but you wouldn't want to rely on the fact that for 5 years it's going to remain unchanged. Some source that is saved more than one appraiser, not to just reference, well, I relied on public records. Well, did you save a copy of the public records? Because those public records might have changed in the last 5 years.
Let me also suggest something else. I did an appraisal of a multi-family condo project. Like all appraisers, you run different scenarios to see which one you think is the best answer. Okay, if you can solve so many this amount of time, fine. Solve this many time, okay. You go back and forth with all these numbers and figures. I learned it a long time ago. Don't keep any of that in your file. Get rid of it. The reason I know this isn't after the attorney got the tuning on me for about 3.5, 4 hours. He said, you know, you appraisers provide us with the best source of information to destroy you. You have to be careful, and I'm just concerned that we get overboard about what we're trying to keep to make sure we're in compliance with the law versus what happens in the real world and real practicality. That's my concern.
I have a question.
Yes.
When the review appraisers are hired, I know we put it out to a bidder, and stop me if I'm violating some due process conversation here, but we put it out to a bid, and then presumably we look at their qualifications, and then are they hired? board, who interviews the review appraisers that we use? And could this body review the review appraisers? Because ultimately, after due process, we are the jury of their peers. We are the jury of the respondents' peers.
Yeah, I think we've addressed this on a couple different commission meetings, but we definitely have some newer members. The experts are hired by the attorney. So the experts are engaged, I should say, not hired. They're engaged by the attorney as expert witnesses. So they're working for legal counsel.
On contract, though.
On a contract. And there's minimum standards in these, there's minimum requirements in the contract. You have to be a certified appraiser. You have to be certified for a certain number of years. Your assignment has to comply with minimum professional standards of use about yada, yada, yada. And then they bid on it, how much they're going to charge. Just like you would for a lender saying, you know, I want you to do this job, how much would you charge me for it? It's the commission, your opportunity to weigh the credibility of an expert will be when they testify in a hearing. And you will say, I believe this person is right about what they are opining on, or they're wrong. And, you know,
What a vast waste of resources if a respondent has to respond to this review that peers would not necessarily oppose. I mean, it's a waste of the state's resources. It's a waste of the respondent's resources.
we could go back to having the commission members do free reviews for the
That's not the
complaint
point.
process.
I can appreciate that.
At some point, we've got to have a peer
We could have
review.
the director do the review.
Right, exactly. We get, at some point, you're going to have a peer, somebody who is the assignment equivalent, review that work and say whether they believe that they met the standard of care, the minimum standard of care. Not like, oh, you were the best appraiser ever, but the minimum bar, you were just above it, beautiful. And that's for the commission to decide.
I submit respectfully that we ought to review the reviewers in some capacity.
In some capacity, I assure you, they are being scrutinized by the attorney and staff.
Those aren't appraisers.
What?
Oh, you mean the staff? I'm sorry. I didn't. Flippant.
Anyway, I appreciate you putting it on there, Nicole.
Mr. Johnson said.
I had a quick question about the cost, since we're going down this rabbit hole.
Excuse me.
What's the annual cost of our litigation expense? Just for the reviewers, you can be off by $10,000.
I'd probably be off by way more.
20's okay. I don't care. Just a ballpark.
That might be something.
It
More-
varies
more than
greatly. We're a
100,000
little
or
behind on our complaint reviews.
Are you asking about litigation, like as far as formal?
No, the expert witness reviewer. What are we paying that pool of individuals more than 100,000 a year in aggregate? 75, 50?
More than 50.
Would you like to bring that answer to our next meeting?
I can figure it out. But it still will vary because the complaint component is an unknown. Like, I don't know how many complaints I'm going to get in this year.
See,
Varying.
Also don't know how many.
Some of them say it was not
Right, send it.
reviewed by a reviewer, it was an administrative call, which is good. And then some are reviewed by the reviewer. And so those, I was just wondering, would it be more cost effective to hire our own reviewer as a staff person? Would it be cheaper than in somebody that the commission has said, yes, this is a go-to person that we want to? And that way it takes some of that subjectivity that Commissioner Lorraine brought forth, maybe out of the equation.
It would be, but there would also be, you'd lose some of the geographical competency. You would also lose, if you put it on one person. Like for a while, it was sort of just me.
There's no way to get 100% caught up.
I can't, we get over 100 complaints a year.
So we're talking about 100 reviews?
More, probably 90. 80
I
or
mean, the
90.
majority of the things that show up on our complaint report, we have to.
Yes. let's get booking, and we'll just have 5 minutes of quick. We'll just distribute the work and go. We discussed online qualifying continuing education. I think that maybe it might be considered more stringent than the federal requirements. You might want to consider changing that, but that's for the commission to decide. The CFPB is the one that regulates reasonable and customary fees for real estate appraisers per Dodd-Frank. They are supposed to be having their law and rulemaking hearing. They also are the ones that do the AMC law and rulemaking hearing, or I should say rulemaking. So their rules are supposed to be promulgated in January of 2013. So please stay tuned for more on that. It will affect. They are proposing some, and this is still the rumor mill, but $25 per appraiser on the panels of the appraisal management companies for the appraisers who already are paying $40 a year to be on the Federal Registry. So, yikes. I don't know. I kind of had some problems with double feeing the appraisers on that. And my last recommendation to the commission is that we establish work groups between the 7 of you all, remaining 7 of you all, to split up the work that needs to be accomplished in the coming months. Here's how I would recommend it. It's on the director's report. Education, review the language and recommend CE and QE criteria to meet the 2015 criteria. This is going to be a very big, giant sections for rules 2055-2 and 1255-4. And also network outreach for a new education member. Right in the midst of all of these changes, Dr. Burla's term is coming to an end. There is a requirement that we have an education member that be a person from a college or university that teaches something related to, God, there can only be a handful across the state, so if you all know of somebody,
I do.
we need to reach out and maybe have a conversation with the governor's office and see if this person would even be interested, because we got to get ahead of this. We can't be behind this. We need somebody to fill this slot. And hopefully at least give an opportunity for Dr. Burla to train them a little bit on how to do this, because
They have to be currently teaching, if they just be a PhD to go from real estate.
I'm not sure. I have to read how to. I think there's some flexibility with that one because there's only one education member, and you know, I mean, what are you gonna do? I think there is some flexibility to that. And that's part 2, creation. One of whom shall be a full-time educator of appraisal-related education with the state's universities, colleges, and junior colleges. That's how it reads.
Full-time.
Full-time educator. So to me, that is a very small group of people who could possibly fill that position. And Dr. Burla has done a tremendous job for us to the point I feel like I abuse him. And then I would recommend he develop an SOP for reviewing education. So the next person, he and the next person complies with the ASC policy statements, all of which have changed also. Application and experience, we're going to have to change all of our applications. Yeah, thanks. Develop standardized compliance review form for experience review. You all do those experience interviews, so like a little checklist for compliance with USPAP, minimum standards, something to document in the file. Review language and recommend changes for application and experience review. That would be 1255-1, 1255-3. Review the USPAP section is really brief, and the inactive standard status rule, those are really brief. They're like half a page long. And recommend any updates, and review all of the applications on the Shriek website for ease of use, consistency, regulations, and recommendations for improvement. The good news is that in theory by next year we're going to have web-based applications, which means you can apply online, type your stuff in on the website, and submit your documents that way. You know what happens when you leave the room? Tell him, Mr. Phillips. You get drafted.
I'll serve on that one that you just read off, and I'll serve on legislation.
Okay, got you.
Okay. Publications
Have a safe
and
trip.
public outreach.
Very good.
Write newsletter articles on topics relevant to regulation of appraisers and appraisal management companies. The goal should be a quarterly newsletter, not an annual newsletter, followed by the commission members with the assistance of TREAC staff. Develop and maintain outreach to licensees for proactive regulation of information. Can't just be me. And keep commission informed with monthly reports on the activities of the professional organizations and schedule times on the agenda for these groups to attend. Okay. Legislation, which would be a big, gigantic undertaking. Review all the laws under appraiser, real estate appraiser, and AMC laws. I went through it once, but that doesn't mean I'm perfect and I got everything, but I went through it once and did my red line version. Work with professional groups to move forward on AQB required background check and fingerprint law requirements. Work with professional groups to move forward on reciprocity requirements. Dodd-Frank. Review reciprocity rule 1255-6. It's short, it's easy to fix. And fix biannual to biannual AMC part of the law. And anything else that may need to be fixed in the AMC regulations, but I didn't put that in there. And then AMC, review AMC rules. I would volunteer Jason for this one. Assist staff in development of forms consistent with other states. Monitor the CFPB rule development for AMCs and report to TREAC. And monitor the ASC National AMC Registry for development in progress and report to TREAC. And I would like somebody to stay attuned and have a monthly update on USPAP stuff to the board. You know, write letters, you know, read the exposure drafts from the standard board when they did it, and that way and help propose language for a letter from the commission to the standard board when they have USPAP changes saying we're for this or we're against this. We can make it part of our monthly commission meeting saying on page 19 of your exposure draft, we think that stinks, don't do that, whatever. So those are the groups I recommend. I have little packets for each of the groups, which I will mail to Mr. Green.
Okay. Well, under application experience there, Mike Green indicated he'd be willing to serve on that.
Okay.
And I'm gonna ask
We just
her.
really need one person on each.
Okay. Publications and outreach. I was going to ask Rosie and Nancy if they would work on that one.
I like taking the last, if I understand the question
Okay.
correctly.
All right, you got it.
I think I should be able to help with the legislation.
Okay.
And that may be a group that we have several people that can.
Yeah,
I was thinking
We all
Mark.
got different.
I was thinking Mark Johnstone and you, Mike Green.
Nancy had expressed an interest in that as well,
Okay.
in the appraisers correlation. So that might be a cumbersome task that we could all work together on.
All right, let's just hand this stuff out. All right, well,
Does that take care of it?
I only made one copy of these drafts. I made two, if you don't want it. I made one copy for you on what I wrote. This is just a draft. This is just Nicole's thoughts on the current laws. Please know that that's just Nicole's thoughts and not, you know, like you should do this or whatever. And wonderful. Actually, I do have two copies for this. Mr. Johnstone. We have Gorilla. This one's green. I will mail it to him. Covington volunteered so kindly. Miss Johnson, you get the smallest packet, but however, newsletters are fun, let me tell you. I would love something from the perspective of a lender for the next newsletter. And I will email you the current one so you can check
That'd
it
be
for
great.
errors and mistakes. That'd be great.
Have to slip out.
All right, we were done
Thank you,
anyway.
Rosie. Appreciate it. Come more, hello, board.
Mr. Phillips. I have an exposure draft for you. Do you think you can maybe by the next commission meeting give the commission your thoughts on it? I'll put it on the agenda. Because the deadline to make a comment is the end of January, like the 25th or something. So if we can, if you have something written up, the commission can vote on it, and we can submit it as a full commission. No one appraiser, no one your commission member can make an opinion on any of them, and you all have to follow the public meeting requirements, so you can't meet privately on these topics. You still have to meet publicly, so on the agenda.
How do they meet publicly as a group, as a committee?
You're still gonna have to do it. You're gonna have to, no.
You have to go sit out for those conflicts.
Unfortunately, that you're still
Shout out your answer.
you're still bound to it. So if you guys need to meet, then I'm gonna have to do a meeting notice. Yeah,
Maybe we can even have a committee.
that's why I
to meet.
recommended it be only one person. Public meetings, Open Meeting Act, it stinks. I think it sucks too.
So we can't talk about any kind of business outside of.
Or business. You can talk with other people about your individual thoughts. You just can't talk about anything you're going to vote about amongst yourselves. You know what I mean? I'm not trying to be mean.
Everybody good on that. It's pretty serious.
Pretty serious.
I think
And yet they wonder why we never are able to accomplish anything.
Well, if you
I
go
wonder
through
why.
these rules.
I wonder why. If you can't ever meet with somebody and talk to them about a quote public meeting, how do you ever get anything accomplished? It's not we're trying to hide anything, but at $50 a day, it doesn't make a whole lot of economic sense to have to come up here for an open meeting so we can discuss what you Pat ought to say.
I don't know. Mr. Johnstone, if you could get the legislator to change the Open Meetings Act to allow subcommittees to meet privately, that would be
Well,
great.
I can expand on that a little bit. We can't, in the county commission, we can't do it either. And we've tried to, we said we need the legislature to operate under the same rules that we as counties have to operate under. We ain't gonna do that.
Well, that's why I thought if everyone got an individual task to look up just a little bit, because right now it's been me on all of these tasks.
Well, like,
can't do
for
it
this one
anymore.
that has 4 individuals working on it, I think the easy way to do it without is just go through it briefly on your own, boom, boom, boom. We get back in this next meeting, we can kind of formulate a plan or let Keeling or somebody say, this is our thoughts, and then once we get a plan of attack, we need to meet here one day on the Hill and go visit with legislators. Then she can put out a newsletter that a meeting that we're going to meet here and go visit legislators. If they want to tag along, then tag along. I mean,
What?
not that big a deal.
Check and make sure.
Topics that are inside of
I think that's all of yours now.
Or the big prize.
Okay.
I think it's just broken down by,
Nicole, do you have anything else to come before the commission?
that's it.
Okay. I want to thank everybody.
Wow, I was going to look at
Yeah, I want to thank everybody for being here, sharing your thoughts and observations with us. I want to thank Nicole and Judy for their hard work and for helping keep us in line and help us also to meet the requirements and deadlines that we're faced with. Without some prodding, I feel quite confident we will not accomplish anything. So we do appreciate that support. And also congratulations to you, Nicole, again, on being elected vice president.
Thank you.
And
I'm still not sure if it's a privilege or a punishment.
well,
Figure it out.
That's a good point. I just don't know either. But we hope it's positive. But you're very dedicated and very able, and so that we are very proud to have you as our executive director.
Please leave your iPads. Please leave your name tags. You can take the paper stuff with you. I need your time sheets if you didn't already give them to me. I think that's it.
You need the receipts for the hotel?
Yes. There's a button on the top that you hold down.
Yeah, oh, it's at the top.
Just hold it down. Like it's like up here.
What's up here?
Opposite end is where you are. Top right. Top.
Other top.
I make a motion, we adjourn.
I have a motion to adjourn. Do you have a second?
Second.
So moved.
Right here. Sorry. I'm not doing a very good job of finding it.
Right here?
Yeah, just hold it down and then it'll